Yeah.
Yeah, Lordship. Lordship, I get the mention for listing on IML for suspension of sentence.
For
Suspension of sentence. So they have to move. Oh, may I please your Lordship? In this case, my lord, the condonation of delay is condoned, my lord. Criminal appeal not been admitted, my lord. For listed for day after tomorrow, my lord, for admission. Complex.
May I please lordship? My lord, I beg to mention item number 7, with the consent of the other side, my lord, is present here, my lord. My lord, your lordship was directed, your lordship was directed to file, assets liability appeal report. My lord, my affidavit is dated, my lord, today we are going to file.
you're
my
for
lord.
the respondent.
I am for the appellant. And
The appellant has filed.
Madam, I am appellant.
he is appellant. I am for the respondent, my lord.
That's why.
Yes, my lord.
So you have not filed. Appellant has filed.
The appellant file. My lord, 2 weeks time, my lord.
Why?
Maybe need my lord to file the assets liability. Affidavit. my lord.
The order was passed earlier to file.
Yes, my lord.
20th
yes, my lord.
March.
From Silchar, my
Huh?
lord.
20 March.
20 March.
20 March.
Yes, my lord. 20 March.
Then
I have the order, my lord.
you
My
have
lord,
the
our
order.
affidavit
If
is,
you are not complying
my
with it, why should we allow you?
my lord, affidavit is
We will
ready, my
keep
lord.
it. The affidavit is ready, so why do you need 2 weeks to file?
My lord, actually, the respondent is supporting various elements, my lord.
So
Earlier we informed, my lord, he has
so
come,
Mr.
my lord.
Counsel, we have been
My lord.
we have been lawyers also.
My lord, on 20 will be fixed
Rest
for
right. Mister, what is
T-shake, my lord.
Huh?
T-shake.
He take Senate counsel for the respondent.
Right.
Wife. Submit that.
Husband, my lord.
Husband, submit that. He needs 2 weeks time to file. Affidavit. Regarding the assets and liabilities
My
in terms of the judgment of the Supreme Court in Rajneesh versus Neha.
Yes, madam.
Submit. The affidavit is ready. Mr. P.K. Deka appears for the apparent wife and submits that affidavit has already been filed in terms of the order dated
20 March.
20/03/2020. On considering the fact that the order for filing affidavit had been made in March 2025. The apparent is granted 3 days time. The respondent is granted 3 days time to file the said affidavit. Failing which an adverse inference may be made against the respondent. This is the matter.
That may be fixed.
When?
20 November 20 November.
Next week. This is the matter.
Briefly obliged.
High level.
May I please, Lordship? I beg to
Next time you don't file, we are going to impose heavy cost upon.
But today I am going to file.
You're going to file today, then we'll
Sir.
list it day after tomorrow. Huh?
Already ready. man.
You said he's ill. Now, you. Huh?
My lord, he was my lord.
He was.
Yes, my lord. That's why we late, man.
May I please, Lordship? I beg to mention for listing IML for
IML.
suspension sentence meeting.
When?
Day after tomorrow?
Similar to a Lordship, and I in connection with 369/23
No.
and another Lordship,
Why day after tomorrow again? Thursday.
next week Lordship, any day,
Next week. Okay, next week. Next.
Thursday, Monday.
We are hearing. Now, item 4 is for orders. That's why item it has started. That's mention is gone. It is gone.
May it please your Lordship. Actually, as per the last order report was called for, it is a flag D. The report says the mental health board says that he has to be shifted to a mental health establishment.
Okay, that is one aspect. But what about, we do not know whether he was mentally sick at the
time of
time of the incident.
My lord,
Let
That's a
us
separate-
clarify that aspect.
that is separate because that is not a plea in his appeal also. But if your Lordship goes to this act,
No, that is all right. If we find, let us first decide the appeal. If the appeal succeeds, he'll go to a mental health. If the appeal does not succeed, he'll still go to a mental health institution. So let us decide whether at the time of the incident, he was a unsound minor.
Exactly, my lord. He's assuming he was a mental ill person at the time of incident. Or if he is not a mentally ill person at the time of incident. Today, he is a mentally ill
No,
person.
no, with the concept, we're not on that. Today he might be,
Yes.
but you see, to come to see whether the judgment of the trial court
My lord.
is correct or not, the issue to be decided is whether the evidence on record would prove or give a reasonable doubt as to whether he was mentally stable or not at the time of the incident. We have to decide that.
Yes.
So let us decide that first. We'll do the appeal. Let us decide the appeal. Then we'll decide this. We'll decide that. We cannot just close the thing just like that.
No,
Let us-
I'm not on that. Appeal will still remain, my lord.
No, appeal will decide the appeal. Then we will decide whether to go for that, to go to a mental hospital. Let us decide the appeal.
Lordship,
Let's decide
maybe
it now.
tomorrow, my lord,
Fine.
nothing has been given by our.
No, nothing is here. We will see, let us see. Just let us see if there is anything, if it's difficult, we'll give you time.
Lordship takes up the paper book.
Yes, paper book, yes,
At page 4 is the FIR.
yes.
LCR put
Is the law court department. Yes,
Page 4 is the FIR. It's dated 15/1/2016. Sir, I have the honor to state that at around 4:30 PM on 14/1/16, when my sister-in-law Srimati Pramila Devi asked her distant relative nephew, Sri Puniram Nath, he is the appellant, to bring the cows from the grazing field, he suddenly and without uttering a word hacked her to death with the dowel he was using to cut firewood in the backside of the house. Immediately, with the help of the local people, he was apprehended and the police were informed. I therefore pray to you to take necessary legal action in this regard and oblige. When FIR was registered, he was charged under section 302, which is at page 6, the charge order. And the PW1 is at page 9. Informant Bipin Chandra Das is my brother. Deceased Pramila Devi was my wife. I know the accused. Occurrence took place on Uruka day of Magh Bihu. It was in the year 2016 at around 4:30 PM. At that particular time, I was keeping the house of my son who was residing at Manipur. On that time, my daughter-in-law received a phone call from my house at Tukmoni that accused Puniram Nath had made cut injury to my wife. Then I hurriedly went to my village house, and on reaching there, I found my wife was being crowded by the village people. I have seen the dead body of my wife lying on the ground and the place she used to cut logs. I have seen cut injury on the back of her head. Accused was distantly related to me and he used to reside in our house and used to help my wife in doing household works. I have seen the accused being tied to the post of my house, and when I questioned him, he told me that at that time my wife told him to tie the cows as she will cut the logs inside the house. Then he protested as it was not the proper time to cut the cows, as because my wife pestered him, he got angry, dealt blow on her head with a dowel. Somebody informed the police. Subsequently, police reached the spot and took the accused to PS. Cross. Accused was staying in my house since 10-11 months prior to the date of incident. Accused used to stock logs and also used to tying cows. All except his work, he does not work anything. Within 20 minutes of receipt of information, I reached my village. It is not a fact that accused Puniram Nath did not confess for me that he had murdered my wife. PW2. I am the informant in this case. This is Pramila Devi was my sister-in-law. I know the accused. He is distantly related to us. At that time of incident, the accused was used to reside in the house of the deceased and used to help the deceased in household works. Occurrence took place on Uruka day of Magh Bihu of last year. At that time, I went to bazaar and no male members are at home. Husband of deceased Pramila Devi also went to bazaar. After finishing marketing of my wife phoned and told me that Puniram Nath murdered my sister-in-law. Then I straight away went to my house. On reaching there, I have seen the dead body of Pramila Devi tying on the backyard of the house. The accused was tied with a pole by village people, and on questioning him, he was told that he got irritated as deceased pestered him to tie the cows. The accused stayed in that house since 7-8 months prior to the incident as male servant. Exhibit 1 is the FIR, 1 is my signature. Exhibit 2 is the seizure list where my signature is taken. Exhibit 2 is the seizure list of the dowry. Accused used to work of cutting logs and tying cows. It is not a fact that I am deposing falsely that accused Puniram Nath confessed before me that he murdered my daughter-in-law. PW3. I know the complainant. I know the deceased Pramila. I also know the accused person who is present in the court. The alleged incident occurred around 1 year ago. The alleged incident took place in the evening time. I am one of the neighbors of the deceased victim. On the day of occurrence at about 4:30 p.m., some people gathered in the house of the deceased. I also heard hue and cry. I immediately rushed to the place of occurrence. I saw the accused running with a dao in his hand. I found the accused behind the house of deceased on running condition. The village people were also running to catch the accused. The village people caught hold the accused and immediately the accused threw the dao. The accused person admitted before us all that he was working in the house of the deceased Pramila Devi, and when Pramila Devi asked him to work more, the accused got agitated and cut the deceased. He admitted that he killed the deceased Pramila Devi. I also saw the deceased lying on the backside of her house. I saw the deep cut mark on the neck of the deceased and oozing blood from her neck. Many people gathered at the place of occurrence and Pramila Devi died immediately. Therefore, police came to the place of occurrence and took the accused. Later, Pramila Devi was cremated. Cross. I saw people were running to catch the accused. I also followed the people. I did not see the incident of killing the deceased. I cannot remember on what side the deceased sustained cut injury on her neck. It is a fact that the accused did not confess his. It is not a fact that the accused did not confess his crime before the village people. PW4. I know the complainant and the deceased. The deceased is the sister-in-law of the complainant. I know the accused who is the nephew of the complainant. Alleged incident occurred in the month of January 2016 on the day of Uruka. The accused is also the nephew of the deceased. The accused was staying at about 8 months in the house of the deceased prior to the occurrence of the incident. On the day of occurrence of the incident, in the evening, the accused was cutting woods and at the backside of the house of the deceased. At that time, a hue and cry took place, and hearing the shouting of other people, I went to the place of occurrence, from where I received the sound of people. After arriving at the place of occurrence, I saw that Pramila Devi, deceased, was lying on the ground. We saw deep cut injury on the neck of the deceased, who died immediately after the blow. There was profuse bleeding oozing out from the neck of the deceased. Many people gathered at the place. The accused was also present, who was carrying a dao by which he killed the deceased. On seeing us, the accused ran away from the place by carrying the dao. The accused, after running a little distance, had thrown away his dao in the field. However, some people who were present in the field caught hold of the accused. Thereafter, the accused was brought to the house of the deceased. Police was informed immediately. Media personnel also arrived there. Police arrested the accused and took the dead body for postmortem. I saw blood stain on the dao by which deceased was killed. Police seized the blood-stained clothes of the deceased in my presence. I put my signature in the seizure memo. Exhibit 2 is the seizure memo. 2.2 is my signature. Police recorded my statement. Cross-examination. I did not state before the police that I came to the place of occurrence after hearing the hue and cry. Police did not ask me about the incident. I went to the police station for putting my signature. I did not see the incident of killing of deceased by the accused. I saw the deep cut injury on the neck of the deceased. The head of the deceased was almost chopped off. I do not know as to who is the owner of the blood-stained clothes. It is not a fact that I have deposed falsely today. PW5 is the PM doctor. On 15/1/2016, I was working at MNHO at Morigaon Civil Hospital. On that day, I performed the postmortem of late Pramila Devi, 62 years female, wife of so-and-so. The dead body was escorted by UBC Pranjal Soikia, Bipin Chandra Nath and Dimbeshwar Nath. A female dead body was examined whose eyes and mouth were closed. Rigor mortis was present. A deep lacerated injury was found in the left side of the neck, extending upwards towards cervical region with cut red vessels. Another lacerated injury was also seen on the left frontal parietal region, about 2.5 into 1 centimeter in diameter. Internal hemorrhage noted in the left frontal region. Fracture of the left side of the mandible in the region of the angle of the mandible. Lacerated injury was seen the left joint shoulder in upper part 1.5 inch into 1.5 inch. Opinion. In my opinion, the cause of death was due to hypovolemic shock due to external hemorrhage and internal hemorrhage in the brain following cut injury by possibly sharp weapon. Exhibit 3 is a postmortem report. Exhibit 3.1 is my signature. Cross. The postmortem examination was conducted at 12:10 p.m. Rigor mortis was present in the dead body of the deceased since the death was occurred within 24 hours before PM examination. PW6, Dimbeshwar Nath. I know the informant. I also know the...
Who is he? Who is this PW6?
My lord, he is one of the people, villagers,
Neighbor.
neighbor. I know the informant. I also know the accused person and the deceased. They are residents of our village. The alleged incident occurred about 1 year ago, which took place at noon at about 3 p.m. On the date of occurrence of the incident, at the relevant point of time, I heard hue and cry at the house of the deceased Pramila Devi. I came to know that the accused person who was working as a laborer on that day at the house of Pramila Devi had killed her by a machete. I came to the house of the deceased and saw her dead body. She was lying dead. Her neck was almost chopped off. There was profuse bleeding oozing out from the body. Accused was running away from the house of deceased after committing the incident. The village people ran after the accused and caught him. The accused person was brought to the house of the deceased and his hands were tied by the rope of our village people. Thereafter, police was informed. Police arrested him after coming to the house of the deceased. Deceased was also taken for postmortem examination. Cross. I did not see the assault made by the accused on the deceased. I saw the accused when he was brought to the compound of the deceased and saw that his hands were tied by a rope. I did not see the machete by which deceased was cut by the accused. I came to know that the incident from the village people as soon as I went to the house of the deceased. He's completely a hearsay witness. PW7. He was the police officer.
Ayo.
IO. At present, on 14/1/16, I was posted at Morigaon PS as attached officer. On that day in the evening, the OC of Morigaon PS informed that an incident of murder had taken place at village Pakumoni and I was directed to reach the place of occurrence. After making a GD entry bearing number so and so, I went to the place along with my team. The OC of the PS also accompanied me. We also informed our executive magistrate regarding the incident. Exhibit 4 is the extract copy of the GD entry. We directly went to the house of the deceased. After arrival at the place of occurrence, we saw the dead body of a female, namely Pramila Devi. We have found there is a deep cut injury on the throat of the deceased. We also found head injury of the deceased. Blood was oozing out profusely. We drew up the sketch map of the place of occurrence. Exhibit 5 is the sketch map. 5.1 is my signature. We recorded the statement of the relevant witnesses at the place of occurrence. They told before us that the nephew of the deceased killed the deceased, namely Pramila Devi. We also found the accused at the place of occurrence who was detained by the village people. The executive magistrate was also present there who conducted the inquest over a dead body of the deceased. Inquest was conducted by executive magistrate Mr. Joyantok Bora. The witnesses told us that the accused committed the murder of the deceased by a dhow. Thereafter, he ran away towards the paddy field. However, the village people caught hold of the accused. The accused chewed a dhow, so it was not traced out. However, on the next day morning, the dhow was recovered by us. Accordingly, the said dhow was seized. The said dhow was stained with blood. Exhibit 6 is the seizure list. Exhibit 6.1 is my signature. The said dhow was seized in presence of witnesses. On the next day, formal ejahar was lodged by the informant. After arrest of the accused, he confessed his crime that he committed the murder of the deceased. All the witnesses have straightaway stated that the accused committed the murder of the deceased. Thereafter, on being transferred, the case was handed over to my successor. Cross. During my investigation, I did not find any direct witness who saw the actual incident of commission of murder. The dead body was sent for postmortem examination at night at around 9 p.m. I recorded statement of Gajen Nath and Kapil Nath, but they did not see the accused running away towards the paddy field along with the dhow in his hand. It is not a fact that I have not done the investigation properly. PW8, Monju Gogoi. I was posted on 25/2016. I was posted at Morigaon PS as SI. On that day, I was endorsed with Morigaon PS case number 17 of 16. My predecessor, IO Samsul Alam, the other person, my lord, had completed most part of the investigation. I had gone through the CD. After receipt of the same, all the relevant documents like postmortem reports, seizure lists, etc. were collected and done by my predecessor, IO Samsul Alam. After completion of the investigation and being satisfied with the investigation, I submitted the charge sheet against accused Puniram Nath under section 302. Exhibit 7 is the charge sheet, 7.1 is my signature. Cross. I personally did not conduct any investigation of the case. My predecessor, IO Samsul Alam, conducted the investigation. I did not record any statement of witness. My predecessor, IO, had recorded the statement of the witnesses. However, after going through the CD, I found that the witnesses have implicated the accused person from every angle. It is not a fact that I have not properly submitted the charge sheet against the accused person. It is not a fact that it is not a fit case to file charge sheet against the accused person. Court witness 1 is Bhaskar Jyoti Pator. I know the deceased. I also know the accused person in the house of the deceased. I went to the place of occurrence on the next day of the occurrence of incident. On the next day of occurrence of the incident, village people went to the paddy field in search of the dhow, by which the accused committed the incident of murder. Accordingly, the dhow was found in the paddy field, which was recovered by police. I put my signature in the seizure list of the dhow. Exhibit 6 is the seizure list, 6-2 is my signature. I heard that the accused had killed the deceased by hitting her with a dhow. Court witness 2, same seizure witness of a dhow. I know the deceased. I also saw the accused person in the house of the deceased. I went to the place of occurrence on the next day of the occurrence of the incident. On the next day of the occurrence of the incident, the village people went to the paddy field in search of the dhow, by which the accused committed the incident of murder. Accordingly, the dhow was found in the paddy field, which was recovered by police. I put my signature in the seizure list of the dhow. Exhibit 6 is the seizure list, 6-3 is my signature. I heard that the accused killed the deceased by hitting her with a dhow. So, my lord, going by all the evidence, there's no eyewitness, admittedly. One lapse, if your lordship goes to the merit of the case, the dhow was recovered the next day. Paul had said that he has run away to the paddy field with a dhow.
And he threw away the dhow.
Threw away the dhow. The dhow was admittedly recovered. One dhow was admittedly recovered on the next day. Two of the witnesses say that there was blood stain on the dhow. Dhow was never sent for FSL, whether it was that same dhow. Now, my lord, I understand. The law is that murder weapon need not be seized. But if a murder weapon is seized, alleged murder weapon is seized, you have to connect that murder weapon with the crime. That this is the weapon which has committed the crime. They have said it's a dhow. They have said it's a bloodstained dhow. The bloodstained dhow was admittedly seized the very next day from an open paddy field, but it was not sent for FSL. So whether that, on the merits of the case, whether that dhow literally was used to commit the crime, that is on merit. Secondly, if that dhow was the dhow, it was also not sent for fingerprinting of the accused, whether it was used. So to link the accused with the dhow, whether he has used it, there's no connection. It could have been any dhow. More so when the dhow was lying there for one full day. It was recovered on the next day from an open paddy field. Could have been any other dhow.
They saw him running away with the dhow.
Exactly, Mera. They have shown me running. If somebody has seen me running away with the dhow and I have thrown the dhow, why did not you pick it up that day? Or why did not you inform the police that day?
It's not that they were running 2 feet behind him. Might be 50 meters behind him, 100 meters.
Completely agreeable, my lord. Completely agreeable. They have said it was evening time, 4 o'clock, a crime was committed. They can see me running with the dhow.
Was he a one sound mind at the time?
My lord, the problem I am facing, to be honest, here there's nothing called, they have not taken the plea. We came to know about it because if it was your lordship's order of condonation of delay, this appeal was filed with a delay of 1500 days, more than 1500. My friend, they had went to the Morigao jail. They had found out that the jailer had said that this is a mental ill person. There is no appeal pending. No, he has never filed. When we checked out, we found out his family has left him. This was the only family who was looking after him. They have left him. Since he was mentally, nobody knows what to do. Then we filed the appeal. This is a ground reality, my lord. The 1500 plus 1560 days, if I am not wrong, it was your lordship's order. The delay was condoned. Subsequently, we filed an application for under 389 to evaluate him because.
But now how are you going to relate back to the date of the incident?
My lord, to be honest, there's no evidence or even suggestion that he was mentally ill on that day. I admit that, my lord. But even then, falling back on the Mental Health Care Act, my lord, whether he is a convict, whether he's an under trial, he cannot be kept in jail.
No, that is a different aspect. The only thing now, for the time being, we have got to decide whether the trial court decision can stand or not. Now, once we hold that it should stand, then we will go into the mental health issue.
On that point, my lord, this is my submission. There's no eyewitness. There's no direct eyewitness. Everybody in the closet said, I have heard from the villagers.
And he has also apparently confessed. Extrajudicial.
Before police.
No, before the PW1 to everyone.
Extrajudicial confession, if your lordship wants me to argue on that, the law is, my lord, the law is, if I am confessing before my friend, my relation to him has to be shown. That I trust him, that I have done something wrong. I going around that telling anybody on the streets that I have killed Mr. ABC, that is not.
You were in their house, living in their house for a few months.
I understand.
You are related also.
PW3.
Neighbor.
No.
Exactly, my lord.
Mentioned him as a nephew, one of the.
PW1 says,
PW3
Accused,
says, my lord.
accused was distantly related to me.
Yes, my lord. He was not there at the place of occurrence.
No, whatever.
Yeah.
And distantly related to me, accused was staying in my house since 10, 11 months
My lord.
prior to the date of incident. In his cross-examination, he says. So he's not only a relative, he's been staying in the house
House.
for 10, 11 months.
My lord, I am handicapped in those points. I understand. Even then,
PW3 also, my lord.
Huh?
PW3 also
is a
says,
neighbor.
PW3 says he admitted before us. So there can be other people also.
Yes.
But going by that, my lord, just whether I had done it, the best possible evidence, the best evidence was the Dow.
No, that is no doubt true that it should have been sent for FSL, no doubt. But then since it has not been done, now whether that can be the only
Yes,
evidence
but
that
there's
will
an- there's
decide
another-
the fate of
another-
the case.
My lord, I was not prepared for hearing with the citations, but there's another law.
Ah,
If an offending weapon, alleged offending weapon is seized, if
Huh.
it is seized,
correct.
you have to show it to the postmortem doctor that whether through this injuries could be done or not. You have to take his opinion on that. Suppose it's a knife and there's a hacking thing. We have to ask the doctor that can this knife cause that injury?
But
And
they,
it
they
is-
have
it-
not challenged
No,
the
no,
in
I-
cross-examination.
That is the ground on the, that is a duty of the prosecution. They have to prove. If your lordship gives me, I can give those citations. These are, you need to show that. Suppose a weapon is not seized, that's a different thing. Then it's a different thing. But if a weapon is seized,
If that is the only evidence, maybe you have got a case. But here there are other evidence. The
and
evidence of
everybody says they saw
now
him
there
running
is,
out.
there is
running out.
nothing to show there is any enmity between
Yes.
these persons.
That-
Why
that-
should they
I admit that.
Yes.
okay, and why should he start a 100-meter race and everyone running behind him with the Dow?
My lord, then coming to that thing, this becomes a case of circumstantial evidence. For circumstantial
correct.
evidence, you need to prove the motive. Eyewitness, it's a thing. If somebody has seen it, everybody says they have seen him running with a Dow.
Ah.
That is the first chain. That is the first link to the chain. A person with a Dow is running in the paddy field. Okay, you get hold of him.
And then he confesses.
Huh. You get hold of him, you bring him. He confesses, let it be a fully extrajudicial confession that I have killed so and so. Police comes. Same day police comes. Police arrests him. Police takes the body. But that link to the chain, the Dow, is still lying in an open field.
Mr. Counsel, it's very difficult. Supposing he's been running for 5 kilometers. Where will they find? I mean,
My lord, the IO says he has recorded the statements of the witnesses there. Those witnesses had told him that he had been running.
ah. Anyway,
If your lordship takes PW3 cross at page 12,
ah,
page 12,
yes.
I saw people running to catch the accused. I also followed the people. I did not see the incident of killing the deceased. So no eyewitness. PW4, again, same cross, my lord, page 14. I did not state before the police. I went to the police station. I did not see the incident of killing of the deceased by the accused. Nobody has seen him committing. That is admitted.
No, you see, killing, usually people in more cases than not, I mean, you don't see the killing. Only in a few there are eyewitnesses. Even in a rape case, you hardly see the rape. It's very few people. So, all illegal acts are done stealthily, out of sight. If it's done in the sight of everybody, he's a very bad thief or the killer or whatever. Supposing you and I were to kill someone, I'm not going to kill someone in front of everybody. I'm going to make sure that no one sees me.
I understand, my lord.
Right.
I completely. But then the duty falls on the prosecution. People had said that he was running away with a Dow.
And then he confessed.
My lord, Dow was lying 5 kilometers, 10 kilometers away. When you have taken possession of that Dow the
Then
next day,
there is no cross-examination
I
to the effect that he did not confess.
Yes.
my lord, I'll come again, rely on a separate thing.
But Acharya, are you trying to say that there are gaps?
There are gaps, my lord. There are gaps. Suppose, my lord, why I say, if there is an admitted position that Dow was not sent for FSL, blood was not matched. Why should I cross? If something was not seized on that day, the seizure list says that it was seized the very next day.
But
Why should
where,
I cross?
but where is the cross-examination to that effect?
Which my lord?
Where is the cross-examination
The-
to that, to the effect that the dhow that was seized
Huh.
was not the weapon that was used for killing the
We need
deceased?
not prove it. Prosecution has to stand on its own legs. They have to show that this is the doubt. that
And
was
where
used.
is the cross-examination which says that the accused did not confess to anybody?
That is not there, my lord. I admit. That part is not there. Confessing part is not there. Cross is not there. But even then confessing, what your lordship will see, confessing will come later. He has killed, he has ran away. So people have seen him running, throwing away the dhow. People have seen him throwing away the dhow, but still it was not seized.
You see, it could imply you not cross-examining on the dhow aspect, could imply that you have accepted
That I have
that
not-
the dhow was used for killing.
No, my lord, prosecution has to stand on its own legs. They have to say, my lord, if your lordship gives me until day after tomorrow, I can place the judgments. You have to show if the weapon is seized, you have to link it with the crime. If any weapon is seized. Secondly, if the weapon is seized, you have to show it to the doctor that can these injuries be inflicted by this weapon? If the doctor says no, it cannot be then. Thirdly, my lord, the bloodstains. Fourthly, my lord, if they have said, one of the witness said that she was so badly hit that blood was oozing out, her head was almost fell off. Where is the bloodstain art to see that the crime had been committed there? You need to collect the bloodstain art. Those were not done. I am relying on the gaps, my lord. It's a case of circumstantial evidence. Nobody has seen the crime. Everybody has seen him running away. First, they say we have heard the noise, we had run away and came running. In their cross-examination, they say we have not seen the crime. Only him running away. My lord, can it be that he was running away after the real killer with the dhow? Can be a possibility. You need to prove that is not a possibility.
No, but then
Prosecution has to prove that is not a possibility.
PW1 has said, when I questioned him, he told me that at the time my wife told him to tie the cows as she will take the cut logs inside the house. Then
The
he
reason, yes. ma'am.
as it was not the proper time to tie the cows, and because my wife pestered him, he got angry and dealt blow on her head with a dhow.
With a dhow.
With a
You
dhow.
got the dhow. You got the dhow. Why did not you make it? Send for FSL.
No, that is one aspect. But the aspect is that he has confessed. Now there is no cross-examination that
I understand, my lord.
Remember.
I understand this is extrajudicial part is there. If your lordship sticks to the extrajudicial part, there is no cross-examination. I admit. But setting aside, the conviction cannot be based on simple extrajudicial.
no,
Be-
not only that is the very action of running, having a PT Usha type of a race with the villagers.
My lord, even then I still say,
That
My-
with the dhow, and then he throws away the dhow. Why should he throw away the dhow?
my lord,
If he catches up with the real killer, he'll need that to protect himself.
on a lighter side, this running away thing, it was my first sheet in an application. I appeared before Justice Amitabh Roy. The allegation was that it was seen that he was running away from the dead alley, dark alley, and the body was found there. Justice Roy asked the PP, do you think if I see a dead body in a dark alley, I'll keep standing there? I'll also run.
Not with the Dow.
I understand. My lord, that's what. If the dhow was there, why did not you seize it?
And this is not dark. This is around 4 o'clock.
Exactly my point, my lord. 4 o'clock, your lordship is saying it could have taken lots of time to seize the dhow.
If you would have fully run, the possibility
Yes.
would have been a doubt to link you with that. But you had the Dow in your hand and you have
Threw
confessed
it away.
and you threw it away.
Agree, my lord. But was the dhow linked with the crime? There we end up.
Every day,
No, my lord. I'm not. The dhow is there. There can be 10 dhows.
You want to put the
My lord, I understand. If your lordship goes by extrajudicial, I have no cross-examination on that part. I agree. But as regards the dhow, if I have taken the dhow, you need to relate that dhow
No,
with
that
the
is
crime.
there. That is there. No doubt. You have got to relate.
You have to relate.
Since it is not there,
Hmm.
and
if it- I
and
get-
since there are other evidences, it doesn't mean that the entire case rests on the dhow.
My lord,
There are other aspects that is clear here. If it was only the dhow that was the issue, then all right, you've got a case.
my lord, in that, because of that, why I'm saying, my lord, the dhow has to be shown.
And then how do you come to the issue of whether he was insane or unsound?
That
or
was not
at that
not
time?
there. ma'am. If your lordship wants to rely on that, there's a separate provision for that. It does not matter whether a person is convict or under trial. If your lordship.
Correct. So we'll decide this appeal as to whether the trial court decision should be decided.
Yes, my lord.
And thereafter,
Other aspect, he can file
Yeah, yeah.
petition there, my
No,
lord.
no,
yeah,
your lordship has
that
done.
can be taken care of here.
My
also.
lord,
It can be taken care of because of this latest report.
my lord.
We can send him.
Lordship judgment is there. Your lordship had passed an order. Similar judgment.
Debu Thapani or something.
No, my lord, Upen Basumata.
Upen.
Your lordship, in that case, he was acquitted on the ground that he was schizophrenic at the time
Yes,
of incident.
lordship
At the
came
time
for
of incident.
finding.
No, at
Yeah,
the time of
but-
incident. But my lord, the law says if a person is, if a prisoner is said to be mentally unstable, mentally ill, there are two options. Either the family has to give an undertaking that he will not be committing such issues anymore, or whether he's convicted, acquitted, does not matter. He has to be sent to a mental asylum. Now, I will rely on that or part. Whether your lordship convicts me or acquits me, law says somebody has to take my responsibility. Even if I'm acquitted today, somebody has to take my responsibility. There's no one.
So,
Admittedly,
but if you are convicted,
Right.
if we uphold the conviction, then you'll have to be sent to a mental asylum.
Even otherwise, my lord.
And as soon as you get better, you go back.
Yes, yes. As soon as
To
I get
jail,
better, I go
yes.
back.
Actually,
Yes, yes. That is there. If I get better, I go back to jail.
so that is why let us decide the appeal.
Yes,
Then we say, if we convict him, then uphold the conviction, and he goes to the mental asylum.
And if your lordship takes up 103 of the Mental Health Care Act, section 103.
keep up.
Article 103 Mental Health Care Act. Prisoners with mental illness. An order under section 30 of Prisoner Act or under 144, these are not required, or under section 330 or section 335 of the CRPC, directing the admission of a prisoner with
Mental health,
Health Care
Care
Act
Act.
2017.
you're giving me the 1987.
Now, that has been repealed. That has been repealed. নতুন কোনে আছে? My lord will see this. This act has repealed that 87 act.
Yes, I know. It doesn't have 103.
My lord, my lord, 103 says, an order under section 30 will leave that, my lord, to or under section 330 or section 335 of CRPC, directing the admission of a prisoner with mental illness into any suitable mental health establishment shall be sufficient authority for the admission of such person in such establishment to which such person may be lawfully transferred for care and treatment therein. Provided that transfer of a prisoner with mental illness to the psychiatric ward in a medical wing of a prison shall be sufficient to meet the requirements under this section. Provided further that where there is no provision of a psychiatric ward in the medical wing, the prisoner may be transferred to a mental health establishment with prior permission of the board. Now here the board has said, 2, the method, modalities and procedure by which the transfer of prisoner under this act is to affairs shall be such that may be prescribed. Now, these are how he has to be transferred. Now, this board has given its opinion in flag D that he is suffering from mental schizophrenia. So as of now, so he has to be shifted. Now, if CRPC, my lord, I won't say it's a defect. CRPC does not deal with convicts with mental illness. It's always accused during trial. It does not deal with convicts, but this act deals with both. In fact, prisoner with mental illness is defined as both a convict or an under trial. So either way, my lord, whether your lordship decides my appeal in my favor or not, he cannot be there. In fact, lordship takes up 335. Why I want,
Is there any jail in Assam
my lord,
where there is a psychiatric ward?
Tejpur jail, only Tejpur jail,
Tezpur jail.
only Tejpur jail.
So we can have him transferred to Tezpur jail if we uphold the conviction.
Yes, it can
We
be.
can have him
Can-
transferred
well,
there. And as soon as he gets well, he goes back to a
Yes,
normal, oh, he's
More-
there, he stays there.
Let him be there.
My lord, almost 10 years is over. 10 or 8 years. 8 years is over. If your lordship takes up 335 once, my lord, why I'm saying he cannot be let, even if your lordship acquits him,
Ah,
why he cannot be let go?
But he can be let go to his family members. no?
Exactly, that's what my lord. 335 says that. Person acquitted on such ground to be detained in safe custody. CRPC 335. Whenever the finding states that the accused person committed the act alleged, the magistrate or court before whom or which the trial has been held shall, if such act would not be for incapacity found, have considered an offence, order such person to be detained in safe custody in such place and manner as the
Well-
magistrate or court
well-
thinks.
Oh. This is monitor. Screen.
Well, Lordship,
Yes, yes, yes.
335 1B, my lord.
Yes.
Order such person to be delivered to any relative or friend of such person. 2, my lord, no order for detention of the accused in a lunatic asylum shall be made under clause A, subsection 1, otherwise than in accordance with such rules as state government under Indian Lunacy Act. My lord, Indian Lunacy Act was repealed by the Mental Health Act of 87. Subsequently, that was repealed by this 2017 Act. So provision 2 is in consonance with Mental Healthcare Act 2017. And 17 says that you have to transfer into an asylum, provided there's no psychiatric ward in the jail. There are certain other things, my lord, mental health establishment. It's not those mental hospitals, but certain NGOs or certain things. But here, nothing has been, as per the act, it should have been done, but there's nothing in Assam as of now. Your lordship, on the merit, my humble submission is that the DAO, the alleged,
You can keep the judgment anytime.
My lord.
That's not a problem.
I'll provide.
So you can provide the judgment, you provide that tomorrow also.
My lord.
Put it reserve. You put it reserve. Okay, but finally, doesn't appear that you'll be getting out of the loop. I'm okay.
In that, my lord, one thing, if your confession thing is, if your lordship takes, confession cannot be under duress.
Correct.
Admittedly, he was tied up.
Admittedly, he was tied up here.
And then he says that I had done this.
Well, we'll see, you bring the judgment, we'll,
My lord. Your lordship is keeping it part heart.
no, we are keeping it, as KV. You can give a judgment.
Like tomorrow, by tomorrow,
You just make a short point. And on this one line,
My
point,
lord,
this is the judgment.
my lord, I'll provide.
Don't give too many judgments.
By 2 or 3, 2 or 3.
Ah. The number that doesn't change our mind. Just that the,
I understand, my lord.
the merit.
But even then, on extradition, my lord, he was held captive. He was from that,
You have any
Paddy field.
authority on that, you give that.
my lord, duress under, yes, my lord.
Will- Okay.
Lordship, accused was like, there was extrajudicial confession, as the lordship said, my lord, observe. Before to PW3, my lord. And PW1 also, then he was found running away and he was found throwing away the lordship weapon of offense.
1, 2, 3 also, 2 also.
Lordship. And reason, my lord, for killing, that he got irritated, man.
Ah.
As the victim asked him to do some, like,
Pestering him.
yes,
Must be a nag,
yes,
huh?
my lord.
Is it that the lady was a nag?
Maybe, my lord, it's lordship. So the reason is the apparent cannot be a person, cannot be the like act of a person of unsound mind, my lord. It's quite nature, like his whatever he has said, lordship is quite.
Could be. Just because someone nags you does not give you, does not justify a killing.
Before
The
2% he said, my
provocation- The
lord.
provocation has to be
Provocation.
proportionate.
In
Anyway,
other
that
cases,
is what.
sure.
Yes, I mean, just happen.
These are the factors and nothing, no, like, no defense in 313, nothing. He has not said anything. And your lordship will see the gravity of the offense, my lord. head was chopped off, your lordship. The manner he was, the victim, not
Exactly chopped off. Was there?
head chopped off.
You see, this is the interesting part at PW4.
Lordship.
When you look at PW4's evidence, 1, 2, 3, 4, 5, 6, 7, 8. 8 lines from the bottom. The accused was also present,
Was carrying a towel.
who was carrying a dab by which he killed it. On seeing us, the accused ran away.
My lord will come to the next page then.
Ah.
The cross-examination.
Ah,
I came to the place of occurrence after hearing the hue and cry.
ah.
I went to the police station for putting myself. I did not see the incident of killing of the deceased.
That's all right.
Ah.
That's all right. He did not see that, but what we're trying to say is that, you see, on seeing the people, on seeing PW4, then he ran away. On seeing us, he ran away. Why should he run away? They could have said that, no, he started running after the perpetrator or the alleged accused. Suddenly you take off.
After seeing the people, why you ran? My lord, there I'll say he was schizophrenic. Ground was not properly taken.
So this portion is,
But even then, my lord, this amply says that he was running away with a dog. And they were, if he, my lord will see this, they reached, PW4 reached the place of occurrence. Appellant was there with a dog. Seeing the PW4 and others, he runs. It is not that these persons were standing there giving me a head start. You run this much, then after with there will run. They had been running after him from right that moment. There has to be, that's normal human tendency. There has to be there, they run after him. Then he throws the dog, 4 o'clock. Police comes thereafter. You did not even say to the police that dog was thrown there. It's an open place from where it was taken. Plus, my lord, police had not made those seizure witnesses in the charge sheet. They were brought as court witnesses. Why?
Lordship, before PW1, Lordship, the accused person has said then he protested and it was not the proper time to tie the cows. As because my wife pestered him, he got angry and they'll blow on her head with a dowel.
okay.
If your lordship wishes, the conversion in a treasure for one,
Where's the conversion?
My
Where does it show conversion?
then lordship, I don't find any other material. Grave and sudden provocation.
I don't think there's much. Only thing is that it was poor cycle.
That I leave it to your lordship. The gravity of the offense was too much.
Okay, right. Heard Mr. D.K. Bhattacharya, Senate counsel for the appellate. Also heard Mr. P. Bhuyan, learned additional people. This appeal has been filed against the judgment dated 20/09/2017, passed by the Sessions Judge, Morigaon, in Sessions Case number 57 of 2016, by which the appellant has been convicted under section 302 IPC and sentenced to undergo rigorous imprisonment for life with a fine of rupees 50,000, in default to undergo another year. To undergo SI for another year, for 1 year, for 1 year. Okay. Next up, the prosecution case in brief is that an FIR dated 15/1/2016 was submitted by prosecution witness -2 (PW2), who was the brother-in-law of the deceased. The FIR stated that around 4:30 PM on 14/1/2016, when his sister, no,
Sister-in-law.
sister-in-law, not sister,
Sister-in-law.
sister-in-law, that is PW1.
No, no, sister-in-law is the deceased.
That's that. When sister-in-law. Okay, wait, who is PW2?
Madam, then,
Acha,
Neighbor,
was the
neighbor.
sister-in-law, okay. Sister-in-law. Okay, to the effect that, the FIR stated that around 4:30 PM on 14/1/2016, when his sister-in-law, bracket deceased, asked her distant relative, bracket nephew, that is the appellant, to bring the cows from the grazing field, he hacked her to death with a dao, suddenly and without uttering a word. The appellant was thereafter apprehended with the help of the local police and with the local people and the police were involved. Consequent to, no, pursuant to the FIR dated 15/1/2016, Moregaon PS case number 17/16 under section 302 IPC was registered. Next. The investigating officer, that is PW, that is PW7,
7.
started his investigation. And after completion of the investigation, he submitted a charge sheet having found after completing the investigation, the second IO, that is PW8, submitted a charge sheet, having found a prima facie case under section 30 against the appellant. Next paragraph. The learned trial court thereafter framed a charge under section 302 IPC against the appellant for having killed the deceased with a dao, to which the appellant pleaded not guilty and claimed to be fine. Next paragraph. The learned trial court thereafter examined 8 prosecution witnesses and 2 court witnesses. The appellant was thereafter examined under section 313 CRP, in which he gave a blanket denial of the evidence that had been adduced against. The learned trial court thereafter came to a finding that the appellant had killed the deceased with the dao that had been seized the day after the incident. And convicted the appellant under section 302 IPC. Next paragraph. The learned counsel for the appellant submit that there is no link between the dao that had been seized on 15/1/2016 with the death of the deceased on 14/1/2000. Inasmuch as the CISDA had not been sent to the FSL for examination. Further, the DAO had not been shown to the doctor who had conducted the post-mortem examination on the deceased to prove that it was the CISDA that had been the cause of the death, that had been the cause of the injury sustained by the appellant, by the deceased, which had led to her death. Next paragraph. The learned counsel for the appellant further submit that the basis for the learned trial court coming to a finding that the appellant had killed the deceased with a dove was due to the extrajudicial confession given to the witnesses. However, the learned trial court had not considered the fact that the appellant had given his extrajudicial confession under coercion, as he was under coercion, and it was not voluntary, as he was tied up at the relevant point of time. Anything else? That's all. Good. He accordingly submits that the above would go to show that the reason for the learned trial court to come to a finding that the appellant was guilty for having killed the deceased was misplaced. Next paragraph. The learned counsel for the appellant submits that in terms of the medical report dated 23/8/2024 issued by the Mental Health Review Board, Kamrup M, Guwahati, who had examined the appellant on the basis of the application made by the appellant that is IA Tribunal 341 of 2025 regarding the stand taken by the appellant that he has been suffering and undergoing treatment for schizophrenia for a considerable length of time, the said report showed that the appellant was provisionally diagnosed as per ICD-10 as a case of paranoid schizophrenia in remission, bracket F20.05 on medication with mild cognitive disorder, bracket F06.7 bracket, and hypertension, diabetes mellitus, and lipidemia. The report dated 23/8/2024 also advised the appellant to continue regular medication and attend psychiatric and endocrinology setup periodically for follow. This is in the order dated 14/8/25, the IA. Okay, next. He also submits that pursuant to the Mental Health Review Board report dated 23/8/2024. The District and Session Judge Kamrup M. Guwahati has passed the order dated 22/10/2025. Pursuant to the orders passed in IA Criminal 341 of 2025. To the effect that not to see that to the effect that the appellant was a person suffering from mental illness. And in terms of section 103 of the Mental Healthcare Act 2017, he is to be admitted in any suitable mental health establishment. As such, the Learned District and Section Judge, Chairman, Mental Health Review Board, Kamrup, had was of the view that the appellant should be kept in a mental health establishment as per the Mental Health Care Act 2017 until further order. Next fact. The learned counsel for the appellant thus submit that in view of the appellant now having been confirmed to be suffering from schizophrenia, the appellant, even if found guilty or innocent in this appeal, would have to be kept in mental health establishment as per the Mental Health Care Act 2017, or in the alternative, it would 9. 50. No, 3 to 9. Or should be or should be delivered to any relative or friend in case of acquittal. Correct. Under section 32335 CRP. Next paragraph. No, yeah, the next paragraph, Miss B. Buyan, the additional PP, on the other hand, submit that the extrajudicial confession made by the appellant to the prosecution witnesses clearly proved that the appellant had killed the deceased. Further, the appellant had run away with the dove and was eventually caught by the village. He also submits that the dagger that had been thrown away by the appellant while running away was seized on the next day, was recovered and seized on the next of the incident. the learned additional PP submit that even though the DAO may not have been sent to the FHL, the seizure of the DAO, the same was not the only issue to be decided by this court, to decide as to whether the deceased had killed, no, the appellant had killed the deceased. He also submits that the issue of unsoundness of mind / insanity on the part of an accused will have to be decided on with regard to whether the accused was of unsound mind / insane on the date the incident occurred. So in the present case, and there has been no stand taken by anybody hearing the trial proceeding before the learned trial. The issue of the appellant being of unsound mind during the date of the incident cannot be considered at this stage as the findings of the mental health review board, which was made on 23/8/2024, cannot relate back to the date of the incident, which happened in the year 2016. It happened that when there is nothing to show that the appellant was not, was of an unsound mind in the year 2016. The appeal would have to be decided by regarding the appellant of being of sound mind on the date when the incident occurred. It submits that when the evidence clearly shows the involvement of the appellant as the person who had killed the deceased, there was no reason that this court could not interfere with the decision of the learned trial court. And the impugned decision should be accordingly be upheld. So we have heard the learned counsel. Okay, hearing concluded, judgment is reserved. No, you'll give me tomorrow. Tomorrow. Whatever, item 7. Oh, item 7.
One bits and a 7 bits. One.
Yes,
In this case, during the pendency of this appeal, we had moved earlier a bail application. And he was allowed to go for 17 days on bail due to some family issues. Now we have there is also an I pending, my lord.
so has he gone back? Is he gone back to jail?
Yes, yes. There it was only for an interim period. No, now the whole case is fixed for final disposal.
Yeah.
So if your lordship is ready,
Where
I
is he? Where is he? Where is he?
attack. Very, very Spanish.
In this case, my lord, there are 5 eyewitnesses and all related from the same family, PW1 to PW5. Your lordship will find the paper book at page 4, the FIR. I think they have given me this.
Just. FIR dated 28/9/13,
Yes, your lord.
submitted by whom? By PW?
PW1.
Who his relation to the deceased?
Yes, madam. Just I'm giving it. Just I made the table person. Just a moment. He is the brother of the injured Ainuddin and uncle of the deceased. Stop.
Brother of injured. Injured is
Injured is PW4. Ainuddin Mandal,
I.
an uncle of the deceased. And FIR was lost one day.
Just a PW4. Ainuddin Mandal.
You'll also find in the index itself. The description,
Yes.
the witness name.
Andal Mandal and uncle of deceased.
Yes,
And the name of deceased is
just a moment. Name of the deceased. Just a moment.
Siddiqui Ali.
Yes, Siddiq Ali, SIDDIQUE. 25 years.
Okay.
Now you also will see the time of occurrence is
5:30.
5:30 p.m. 27th of September 2013. The accused person's name below were hiding near Hassan Ali's house. So your lordship will kindly take note that the first witness says that they were hiding near Hassan Ali's house in a pre-planned manner, armed with dagger. So many weapons, my lord. Dagger, dows, and spears. And suddenly attacked and severely assaulted my younger brother and my son. While they were coming from Gaspara, accused Surab and Suhan. And my son, no. Original too. Tried to kill Siddiq. Just let me check the SMS one. Guru Bhai Lora Pishon. Lora Haladam son. I'm sorry, madam. Uru Bhai Lora. That means younger brother and son. In the SMS.
Yes. So
Yes.
Ainuddin is
Yes.
the younger brother.
And my son.
No, sorry.
I have checked.
This is the uncle.
Yes.
Nephew.
Yes, ma'am. There in my
This is nice.
translation, there was some mistake. Mur Huru Bhai, Aru,
And
Lorak, Ramon.
Ainuddin, the injured, is the younger brother of the informed.
Yes, yes. I'm sorry. That correct. I have looked into the original one. That's correct. So your lordship will find they were hiding near Hassan Ali's house. The location, my lord.
Yeah.
Yes. Then assaulted my younger brother and my son while they were coming from Gaspara. So they were coming from Gaspara and they were hiding near, accused were hiding near Surab Ali's house. Accused Surab and Suhan. Suhan, but here the name of the accused is Shubhan Ali. In the FIR, it says Suhane. Okay. Tried to kill Siddiqui and Ainuddin respectively by stabbing them with dagger and dao. However, hearing the scream, the neighbors came forward and found them still alive. But
So who is this? Who is this Torab and Sawahan?
Surab, my lord, your lordship will find in the name and address of the accused person, who is
But out here the appellant is who? The appellant is
Subhan.
Sobahan. Who is Sobahan? Which is Sobahan? This not it is Sobahan. Sobahan.
Ex, my lord.
Sobahan is Sobahan.
Let me check. Then they have not bought it. Let me check that. Suhan. So
That number two. Number two is this Sobahan.
yes, spelling is mistake.
Number two is in the SMS, it is Suhan Ali. In the SMS, it's Suhan Ali.
Some mistake.
Yes.
Yes,
ठीक है,
Sobahan is the person.
ठीक. I will not have, but he says Suhan. It was their duty to clarify it, but they have not clarified it.
It's Sobahan. It's Sobahan.
In,
What does the FIR say? The original FIR.
original FI, it says Suhan. Suhan. And spelling what they have written. Suhan. Suhan. This, what they have written, this is. But they have not established that this Suhan Ali is the Suhan Ali. Because even
Madam,
in,
are you the prosecutor here? Who's taking up this matter on behalf of the PP?
Madam, please be here, madam.
Where is he?
Madam, she also they can defend matter, madam. He's coming.
You see, right now we need to clarify one matter.
Madam.
This issue. Bring her here. Ask her to be here.
Suhan Ali. আৰু ইয়াত লিখিছে সুহান আলী আৰু প্ৰেচিডেণ্টৰ নাম হ'ল সুবাহান আলী. And in 313 also it is written Suhaban Ali, page 33.
So is it Sobahan or Sobahan?
As per,
You'll have to show that Sobahan and Sobahan are the same person.
Madam, as per these,
original to send out paper.
yes, SMS version, madam, it is Suwahan Ali.
So,
Suwahan.
Sobahan, that means W.
SOWAHN.
But everywhere it is taken as Sobahan.
Subahan, madam.
So this Sobahan and Sobahan are the same.
My lord,
Let us see the arrest memo.
yes,
And let us see it from there.
Yes.
From arrest memo, we'll make out their father's name and address. We can't be clear.
On the forwarding report also your lordship will get it.
Huh?
In the forwarding report also your lordship will get it. If not annexed, it will be part of the LCR, PCA. Now it is PCR.
easier to go.
PCR to the more will get. I'll take it out.
It's 90.
What the protocol is.
Sobahan Ali,
Just
son of late Ghaffar Ali. So this Sobahan Ali, Ghaffar Ali.
Shivanshi also Subahan.
So should it be Sobahan or Sobahan? Are they the same
We'll take,
person?
madam.
check. In the according to church.
Holding up.
There's a charge of the sort of period.
I think that the
It's just not there, it's not. Forwarding report comes. In the summon, it is Subhan Ali.
see your appeal petition.
Yes.
Your appeal petition should be here,
Yes,
page 110.
yes, ma'am. Subhan Ali,
So I want to see father's name,
Gafur Ali,
Ghaffur Ali.
yes. Ready? He put gives the number in the look with checking.
Sobahan, late Ghaffur, dash para 23. Dash para 2. Where was that? The name? That went. Yeah. You want to be please?
Shivanshi Subahan Ali.
Steve. Correct. Ghaffur Ali. Ghaffur Ali.
Yes.
Father's name is
One is Sobahan Gafur Ali, but Sobahan, how do we, now, how do we know that Sobahan is Sobahan? How do we know that Sobahan is Sobahan?
I'm checking. So,
iOS PW?
PW nine.
Nine.
Nine. So check.
Eight.
PW,
Where is their APP?
I have to send again.
He's on legs or what?
Yes, no.
How can she be on legs on two court? What is this?
iOS PW 8.
No, how it is? Because I charge sheet submit because PW 8 and 10. Yes, sir. So they are charge it.
Charge sheet, page 90.
Yes, then আমার তো সেশন টেস্ট কেমন আছে
Out here, Gaffer Ali, what is Gaffer? Gaffer Ali, page 91. Top. Gaffer Ali. Abu Taher, who is this?
In the impugned judgment, in the point of the determination, it is written as Sobahan Ali. In the impugned judgment, in the point of determination.
In charge priming order also Sobahan Ali.
So they're the same person,
Same
Sobahan and Sobahan, is it?
Fine.
This burden is on them.
This is something very awkward. Your PP, who is supposed to be arguing here, is having two hearings at the same time. So, huh?
Well, I'm not saying the other day there was in a video conference, there was a lady who was putting two cameras at the same time.
Ah.
And when a question was put, she muted the judge whom she was not willing to hear. So she has been banned from all video conferencing facility of that High Court.
Where, which type of?
I think it is reported in live law. I
Okay.
forgot. She was, so she did not want to answer the query of the judge. She suddenly blank out the, but she made the mistake when he again came online and asked her why. So no, I was in a other video conference. So she is now banned because under the video conferencing rule of that particular High Court, you can, there are certain criteria that you can put it only one online and all.
Correct, you should have only one online. Out here we are having two physical hearings going on in two different courts. Forget about two online virtual courts.
Nowadays, Malad, in the trial court,
Is this something you are starting new? Huh? Is the prosecutors of Assam going to start this trend? Huh? Two physical hearings going on at the same time
ban koi dichi.
in two different courts. You are not taking a judgment here also. You are you could have asked. There's a basic courtesy you should have to the court. We have not said that you should be here.
Ban from
Ask for time.
Yeah, this
Is she on legs? Before which court? 7.
You did not inform us
Huh?
but afterwards.
When he started, you should have informed that she's on legs in another court.
Malad, it's Delhi High Court bars lawyer from appearing online, says switching of video, citing parallel hearing against VC rules.
Out here, parallel hearings virtually, no? Out here, physical. Out here, parallel hearings physically. very competent, can be in two places at one time.
Suhan, SW, SOWA.
But actually, what has happened here in Assam is one is Bo, one is Wakbo. We call it. These are alphabet. So sometimes what has happened while translating, some use instead of Wakbo W, some use B. Because it cannot be proper in a proper sense. It cannot be translated.
Because of, so it's a.
That might-
it's a- So it's the spelling can be B or W both.
Yes, madam. Like
Is it?
my name is Rishi Mana. I can write raw or I can write Re.
Comparison vernacular,
Yes,
Vernacular.
there it is.
Wakbo. Swahan. That is
Swahan.
Wakbo. And that-
SWA, SOWA. So the English,
I've never taken this the other way. That
and they actually what,
Then
Is the
then let's
ah,
carry on.
yes.
that
But
is a possibility.
actually, but normally what we do in the trial court, here in Guwahati, we clarify the name at the trial court itself because otherwise it leads to, because in the judgment and all, it leads to confusion.
Anyway, and so now
Not taking on the name, we'll go by the,
we'll go by what is.
what is there in the evidence.
And because it is in a vernacular, it is Wakbo. I have
That's
seen-
why I have compared, because sometimes even my first,
Anyway, this is the first time we are hearing. I mean, might not be the first time, at least now. We are having two physical hearings at the same time,
And I have
being
plus
conducted by one lawyer.
But can it be picked on tomorrow, my lord?
No, now we are hearing. it.
Yeah.
It's too late in the day now. Yes,
so you'll also will find that they were hiding near Hassan Ali's house,
Correct.
5:30 in the evening, and they were coming from Gaspara. Now you'll also will find multiple weapons of assault have been described, dagger, dao.
correct.
Then hearing the scream, neighbors came and found them still alive but bleeding profuse.
Yeah.
I'll take your lordship to the other evidence also. This place occurred in a public place. And the IO has admitted that although there were some independent or public witnesses, none of them have been examined. They were confined only to the family members of PW from PW1 to PW5. And although the injured persons were later admitted, the accused person snatched an amount of rupees 30,000 and a mobile handset from the pocket of the injured person. Although the injured persons were later admitted into Dhuburi or civil hospital, they are fighting for life. Lodging of the FIR got delayed as I was busy taking care of both the accused persons. So your lordship will find that 1, 2, 3, 4, 5, 6, 7 accusers are their name in the FIR. Now your lordship will see the framing of charge order at the next page at 7.
No, before that,
Yes, ma'am.
how are these 7 persons related to each other? Sharaf Ali and the present appellant, how are they related?
First says all are sons of late Ghaffur Ali. There's number 1 and 2 your lordship will find.
Son of Ghaffur Ali both.
Yes. Then 5 your lordship will find Ajirun Bewa is wife of Ghaffur Ali.
Just a minute. What about this, this number 3 also is son of Ghaffur Ali?
Yes, 1, 2, 3. Sorry.
1, 2, 3.
All are sons of late Ghaffur
Then
Ali.
Hassan Ali is, who is Hassan Ali?
Hassan Ali,
Any relation? No.
Arjun Bewa is wife of Ghaffur Ali. Jarina Bibi is again wife of accused number 1 in this FIR. And Halima,
the wife of
Halima Bibi is a wife of
Hassan Ali.
Hassan Ali.
How is Hassan Ali related to Ghaffur Ali?
My lord, in the evidence, my lord, ultimately the only this Sobahan was convicted, your lordship.
Hassan Ali is a neighbor.
Yes, ma'am.
Okay. Then, okay, let us go there.
Then your lordship will go to the next page at page 7.
Yes.
This is an elementary mistake made, my lord. At page 7, your lordship will find there 1, 2, 3, 4 accused are there. But your lordship will find the charge has been framed under 148, 149 relating to unlawful assembly at first. Because to form an unlawful assembly, you have to have more than 5. Then 307, then 302. Then the commitment order you'll also find at page 9. Let us go serially, my lord.
Commitment order, original commitment order is at page 9. Now we can start from the evidence at page 10.
Yes.
Just a moment. I know the accused present today in the court. I also know the injured and the deceased. On 27/9/2013 at around 5 to 5:30 p.m., I came to the riverside. Having arrived at the bank of the river, I heard the hue and cry. Now your lordship will find that the witness has shifted the location from the affair.
Lordship, I'm so sorry. I was in.
You should have informed us. You wanted some clarification, you were not there. Anyway. Yes,
Then your lordship will find location shifted from Hassan Ali's house to the river. I had heard hue and cry. I had noticed Tahir Ali and Subhan Ali, your lordship will say. I had also noticed Tahir Ali and Subhan Ali armed with sticks running to the place of occurrence. So this is an improvement again made from the FIR. There I had seen Ainuddin Mondal was trying to catch hold of the knife in the hand of Subhan Ali. Sohrab Ali, by means of the stick in his hands, striking blow on the scalp of the Ainuddin. Your lordship will take note of this injuries because I will be referring to the postmortem report and the injury report. So your lordship will keep kindly remember this, Miller. Ainuddin fell on the ground. Subhan, by means of the knife, stabbed on the right side of the belly of the This is again Ainuddin. Tahir Ali was tightly holding the neck of Siddiq Ali. Siddiq Ali had fallen down on the ground and then he had seen Sabbar armed with dagger was running after me. I was saved at the timely intervention of Ajibor and Saddam, who had intervened and removed the dagger from the hands of the Swang. This dagger part also your lordship will kindly take note, my lord. I was saved at the timely intervention of Ajibor and Saddam, who had intervened and removed the daggers from the hands of Sobhan. I had taken both injured person, Ainuddin and Siddiq, to Divri Civil Hospital. Ainuddin had undergone treatment at Civil Hospital. Siddiq had to be shifted to GMCH since his condition was serious. Siddiq succumbed to his injury after 3 days at the GMCH. Prior to that, he has also got an treatment for his injury at the stomach. I will come to that later on, madam. Now your lordship will see the cross was reserved the next page. I had been interrogated by the IO. On the day of the alleged occurrence, I was at my house. The place of occurrence is around 200 to 300 meters away from my house, which is on the other side of the road. The time was around 5:30 p.m. It was immediately before evening prayer time. The place of occurrence is located at a densely populated area. So where this offense occurred, my lord, your lordship will see that he has admitted that it is at a densely populated area. Anwar, which is PW2, Johirul, PW5, Sanwar, Bahadur Surat, Hussein Ali, Mughal, etc., are all residents living in the neighborhood of the place of occurrence. But none of them has been examined this neighbors. There is a BSF post near the place of occurrence. So he also says that there is a BSF post near the occurrence because, my lord, the person who is now facing this conviction, in the evidence it has come out that he had given information to the BSF that these people used to smuggle cows to Bangladesh. So that was the motive, they say, for the crime.
who is this smuggler?
This witnesses, prosecution witnesses, and the deceased and all. And he gave the input. This accused gave the information to the BSF. But they say they say that the genesis of the incident occurred from that information, the original enmity between the families.
Probably both sides are trying to smuggle cows out of How is that having any relevance?
Since it has come out in the evidence, I had pointed it out. Now your lordship will see. Ajibor is my nephew. Ajibor is PW2. Ainuddin is my brother, PW4. And Johirul Haq, PW5, is my brother-in-law. Immediately after the alleged occurrence, many people had gathered at the place of occurrence. I had not told about the incident to any of them. I am one of the accused person in the case filed by the accused persons. In the cross case, the FIR was lodged alleging that we attempted to assault the informant and the witnesses. I had not noticed any injury on the person of the accused. It is not a fact that we had caused injury to Soban Ali, Tahir Ali, and Ajiran, and we had threatened to kill them on seeing them coming on a boat. The BSF personnel remained on guard in the evening at the BSF post. The international border between India and Bangladesh is located around 300 to 400 meters away from my house. It is not a fact that we all along with some other person had attacked the present accused person. I had not written the FIR in the present case. Since my son had died in the alleged occurrence, I filed the FIR. The contents of the FIR was read out to me before the FIR was lost. The name of my deceased son is Siddiq Ali. Before the alleged occurrence, my younger son Saddam Hussein had divorced his wife. About 8 months after the occurrence, my second son, Saddam Hussein, married the widow of Siddiq Ali, the deceased. It is not a fact that my son Saddam Hussein had illicit relation with the wife of Siddiq Ali, for which Saddam Hussein had divorced his wife.
I don't think you finished before one.
No.
Let's make it up to write the.
चलो मेरा जितना सही
And it seems that there are two FIR.
Yes.
What has happened to the other case?
Well, a cross case
case.
information asan ko. These people, they belong to the very economic, just a minute, check out. Cross FIR I have, but the final outcome I don't know, my lord, because this person is in jail. Then his wife comes, she works in someone's house as a domestic help. The FIR number is there. Your lordship can ask the learned PP to take instruction on it. my lord.
FIR number
Just now.
of PSK.
Yes, madam, I'm giving it. Duguri PS case number 834 of 2013. Dated 28/9/2000.
834 of
Duguri PS case number 834 of 2013. And GR cases, madam,
dated,
Dated?
what is it?
dated 28/9/2013.
28/9/2000.
And GR is, madam, GR number is GR within bracket DBB. Bracket,
GBB
yes, that is within bracket 834 of 2013.
834, that is again the same number.
Yes. Same GR number also, they have written it same.
So there must have been some other case also.
Yes, ma'am.
Was there any death on the other side?
No, because these sections are 147, 148, 149, 341, 384, 326, 354.
Fighting over what? Land over?
Well, due to an information given for
That's how,
smuggling car.
smuggling cow.
That's the,
So both of you will want to smuggle.
no, we gave the information because I think they have some reward money for nowadays for giving this information.
Probably you wanted them to get caught and then you will.
I'll not presume, but normally now we have reward money system, well, for informer.
Yeah, I think this will take time. We cannot predict it for defense.
Well, subject to your lordship's convenience. Well, may I pray any date on the hearing in the
Hearing
month of
date.
November? 25th is a Tuesday, 27 is a Thursday, subject to the court calendar.
On the prayer of the party, it's the matter.
I haven't made the prayer. He has.
On the prayer of
It
this,
makes no difference, madam.
with the court, then it is transferred for the evidence. It's the matter on 27.
Yes.
27?
For,
In the meantime, Ms. B. Buyan, Ethical Fifty shall also obtain instructions with regard to the status of Dubri PS case number 834 2004 to 834 2013. Because the
Same
currently be filed by the
May I know the
by the accused person
important numbers?
this is.
in this case. Don't it, it has been filed with that. It's 834 2013.
Sure.
834 2013 dated 28/9/2013. That is.
GR of 774 of 2013,
Session.
session case number 158 of 2016. The record is here.
What is it?
Well, I'll just point out the taller TCR খন দিয়ক. It's there. Seven. আৰু এটা আছে যে, আৰু এটা।
We don't even have to put it reserve. No,
It
we
no,
don't
it
dispose of, how
it
dispose of. Sensor, yes, dispose, dismiss basically. Huh? Yeah.
এইটো দিম। দিয়ক, দিয়ক।
This is 1982. 282. 463.
এইটো।
Para 4, para.
Maybe there was scope for appeal for acquittal also. I don't know, but only after looking. Nale.
Right. Who has taken this photo? Calcutta, is the Calcutta, right? In the cross FIR, cross case filed by the appellant. That is second case number 158 of 2016. Which has arisen from Dubri PS case number 834 of 2013. 834 of 2013. The under section 147, slash 148, slash 149, slash 341, slash 34, slash 326, slash 354, slash 307, slash 90, slash. The accused person have been convicted
No, in this case,
of the charges framed against.
no, in this case, Malay acquitted.
Acquitted,
Yes, no,
that's
sorry.
what I said,
Oh, I had convicted.
of the charges framed.
Malay, your lordship will kindly direct the registry to permit us to take certified copies of it from the TCR because otherwise they will not allow us.
You apply for it.
Malay, your lordship will kindly apply.
There's nothing you apply for. You apply for it.
Otherwise, I think they don't give the TCR.
They'll give you, why should they? Why shouldn't they give? I don't think.
If it is given, I have no problem because we may also
You
now.
apply for it if you can show that despite your application, you're not given, then we'll direct.
Yes. Because we may also now have to file a appeal against acquittal if there is merit power. It's considerable. Obliged to.
May I please look, sir?
What is the most I have to get?
Finish the first case. And subject to your lordship convenience, can we do the second case on day after tomorrow? Anytime convenient to you.
Why don't you do this case before a new judge?
No, no, no. I am going to reply in the first.
Because I have completely lost track of what.
Yes,
So
yes,
there
because
was
I
a
have
tablet.
lost myself, therefore we are in the same mood. I will.
It's becoming very difficult for me with this matter.
No, I'll summarize. Your lordship will see. It will be done, but second case I'll do, because I'll complete the first case today. And
I don't even remember what is the first case.
it's all right. Immediately I'll refresh. Huh?
Item number.
First case.
8150.
8150. Huh? Yes, pretty well.
Yeah, pick. No, I've got the other matter fixed.
Oh, I see. When is Friday will Friday will be difficult for you. Wednesday?
We picked a lot of matters fixed. This morning itself, I was pick for. Wednesday, day after tomorrow.
Oh. Thursday also we have fixed.
This criminal matter, one case is good enough for one day. One day also something not.
That's right.
As a point, it takes a lot of my time. In fact, it takes up more time outside the courtroom than inside the courtroom.
True. Anyway, it is not going to be done today. You are not going to do it today. You can leave. Oh, no, no. Because I am making an assessment of the first case I will take. That's why I am saying.
Why don't you think that before a new judge?
No, 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 don't punish us. No.
Don't punish us. I am being punished.
No, no.
I've never taken so long in one
No,
one matter.
I'll summarize this and your lordship will see it will not take me. Your lordship will remember. I also forgot myself, my lord. So I came over because this was fixed on 23rd. So I came over and to learn that your lordship is not sitting.
23rd year.
Yeah. So I have gone through and then I'll finish that case today. Yeah, written argument is fine. Yeah, good.
Where is my note? Then the other. My God, again this thing. 21 people.
Right. Oh, I see. The lordship has disposed of it. Oh, I see.
Made some notes. So these are 21 pages. Now I have to go through this entire thing.
Your lordship won't have to take that trouble. I'll summarize this very briefly. First, please.
Okay, tell me what.
This is one is the civil rule, the WPC 8150 of 17. That is the first level.
Okay, 8150. So you are challenging the order dated 11/9/17.
Yes. No? Hmm?
No, what is to be done today? What are
And
we doing today?
Below the first case, I argued before Lordship. They have replied to that. Mr. Ashish Dasgupta replied to that, and I am supposed to reply in the first matter.
8150.
Eight was that. And second matter, we have not started as yet because it will be partly of this type. There will be only one additional point, nothing else. I'll just refresh, because speaking for myself, I also forgot everything, so these 2 days I have read. Oil India Limited is engaged, in exploration of crude oil. For that, it has two streams, so far as workers are concerned. One is, through regular selection process. They have their own rules. They advertise and competition takes place, and then they, appoint. And they have their own grades of promotion as they serve, depending on how they fare. The other mode of recruitment is, the company advertises for contractors to supply the labor. That is called the contractual labor, which is permissible, under this Contract Labor Regulation and Abolition Act 1970. The oil company is also registered, and the contractor has to take the license. So the number of people are mentioned in the license, and he has to take. Now, the question of wages is what is now in issue. So far as the contractual workers were concerned, so far as the regular,
There's no problem.
no problem, because they have their from grade 1 to 9, so they have their fixed wages and all that. So far as contractual workers are concerned, there is no such
There is no classification.
classification or any prescription of a scale and all that.
So they all get the same.
No. So there is a need for settlement so far as wage and other allowances are concerned. This has been good.
Depending upon whether they are contractual 1 to 9.
No. As far as regular grade 1 to grade 9, that's a different chapter.
So the contractual,
So far as contractual are concerned, they are recruited and they are supplied by the contractor.
okay, so the,
company doesn't have any,
so the question of payment of their salary
yes.
is decided by the contractor. But then they will be also working different jobs
Correct.
depending upon
The oil
kind of
company will
grades
require,
that has
as
been
per
done.
their requirements, they will employ them there or in different jobs. So the supply of the contractual labor is done by the contractor.
Hmm.
And under this act, the contractor has to have a license.
There's one thing.
Yes.
The work done by the different grades of the regular employee,
Correct.
is the nature and duty of the work different depending upon their pay?
Yes, naturally, because from grade 1 to grade 9 is the breakup of the regular employee. And there are rules for recruitment. You have to advertise.
So even for this contractual employee,
For contractual employees, all that is not needed. The contractor arranges the contractual workers.
so you place them in either grade 1 work or grade 9 work.
No, that they are not graded at all. they can do whatever work we
Can they do the work
yeah.
of a grade 9 permanent employee?
No.
Then
Obviously.
what is the limit that they can
Correct.
do?
They are given, assigned some works which are needed to be done, not by the regular worker, but by the contractual worker.
So they are
So
assigned
it
work.
depends on the nature of the employment and nature of the requirement of the company. So they advertise for contractors. The contractors, people submit their tenders. They select the contractors, but they don't select the employees. The supply of the labor is part of the contractor's duty. So
That
there
is
is
there,
no
that is there.
direct relationship.
No,
employer-employee between.
No, you see, there are two aspects.
Huh.
Now, first of all, the permanent employees, they are graded 1 to 9. Their work depends upon whether they are graded 1 to 9. So grade 1 work and grade 2 employees work will be different, or is it same?
Yes, there is promotion, Milord, one after the other.
Promotion. Is the work the same?
Huh.
Is the work of a grade 1 employee
Huh.
and a grade 2 regular employee the same? Can it be the same?
Because of the, Milord, how promotions are made. You see the service, if there is nothing wrong, you get the vacancy, you have a little interview process is there for promotion.
Where is the other side? They should be hearing what the
Yeah,
questions that we are raising.
Yes, yeah, there.
Senior is in port number for this kind.
You see, because Mr. Goswami I'm asking questions to Mr. Goswami. Now, I want you all to understand the questions I put to him so that we all agree on a certain point or we don't agree on a certain point. I want that to be clarified at this stage.
Yes.
Because the questions I put to him now, when your senior starts,
No, they have already argued. I am only replying now.
you're replying, but again, we are going back and clarifying. And I mean, and refreshing ourselves whether we are sure on the facts.
Yes, yes.
That aspect I want to.
Your lordship is absolutely right about the facts.
No, I'm not right.
Huh.
I'm not clear, but I want to be doubly
No, I am therefore making.
the other side to be there.
Yes, yes. He is there and I am.
Yeah, but he doesn't seem to be aware. He's not listening.
Lordship,
He knows it.
respondent number 2, Deputy Labor Commissioner,
Yes.
during the proceeding, before him, he visited the site, field of the Oil India.
My question is this. There are regular employees of Oil India, graded 1 to 9. Will a grade 1 regular employee, will the work of a grade 1 regular employee and the work of a grade 2 regular employee be the same or will it be different?
No, Milord, may explain that.
Some nature of work is similar. Lordship, statement of the regular employee and contractual employee has already been taken. Page 66 of the judgment.
So the work of a grade 1 employee and the work of a grade 9 employee, will it be the same?
Will be different, obviously.
It will be different. It's not the same anyway.
No,
Or okay, between 1 and 2, will it be the same?
No, Milord, depending on the service period, his performance, the promotion will be.
Or is
different.
it
Promotion is also a process.
no, or is the work the same, but because of the length of service, they're getting a higher
No,
scale?
length of service is relevant because if you are employed at the bottom, you will go up over a period of time from one to the other. That is so far the contractual, the regular employees are concerned. We are not concerned with that at all. So far as this contractual part is concerned, there are people who are placed before the company through the contractors. That is within the definition of the contract labor. When a contractor supplies only, he has nothing else to do. He supplies the workforce.
So the laborers who are supplied by the contractor, their work is completely different from the regular employees.
Not completely or not, it will depend on the deployment they are made for the requirements of the.
So some of them can be deployed in doing grade 3 work.
No. not grade 3 work.
Grade 2 work.
No, no, they are not, just see. So far as regular recruitment is concerned, you have to face very severe competition. For 3 posts, there will be 10,000 candidates. So they are recruited after screening, after interview, and they have to,
Just tell me, grade 1 employee, what do they do?
you know,
Regular grade 1 employee, what do they
Because
do?
this is one thing, that's a process of, there may be different classes of work.
Correct. Can you give an example?
So far as this company is concerned, they are engaged in exploration. So there will be skilled workers, unskilled workers. So it will be different from work to work. So I can't give your lordship the actual.
At least some examples so that I can have a fair idea of what's going on.
No, that I will show, because I have placed those paragraphs, paragraph 17 onwards, so far as this first case is concerned, where we have indicated why you can't equate them with the regular employees. As I proceed, your lordship will get the answer. So I am just beginning. So the 2 streams are largely
Regular employee and
employee and the
contractor.
contractual. We are concerned with the contractual employees now. Now they are recruited, and then, my lord, they are given different jobs. Now, as far as their work is concerned, that is allotted to them and they perform it. And so far as the contractual employees are concerned, they are regular employees are concerned, they are attached to a particular job and they continue as they go on. Now, therefore, my lord, under the Act, there is no provision as to how the wage will be given to a contractual employee. There are 3 modes. As I place Rule 25, my lord, if your lordships recall that rule. First, Section 21. The scheme of the Act is, my lord, that the contractor takes a license. The company which is going to have contract labor has to take the registration, and then, you know, the contractor supply the laborers. And so far as wage is concerned, if your lordships kindly see Section 21, responsibility for payment of wages. Because regular employees have their own scale of pay and all that. Now, so far as contractors are concerned, which is governed under this Act, the wages part, your lordship will see first, Section 21. A contractor shall be responsible for payment of wages to each worker employed by him as contract labor, and such wages shall be paid before the expiry of such period as may be prescribed. Every principal employer, the company is the principal employer, shall nominate a representative duly authorized by him to be present at the time of disbursement of wages by the contractor, and it shall be the duty of such representative to certify the amounts paid as wages in such manner as may be prescribed. It shall be duty of the contractor to ensure disbursement of wages in the presence of authorized representative of the principal employer. In case the contractor fails to make payment of wages within the prescribed period or makes short payment, then the principal employer shall be liable to make payment of wages in full or unpaid balance due, as the case may be, to the contract labor employed by the contractor and recover the amount so paid from the contractor either by deduction from any amount payable to the contractor under the contractor or as a debt payable by a contractor. So far as the act is concerned, so far wages are concerned, this is the provision. Namely that contractor will be liable to pay. If he defaults, the principal employer will have to pay. Your lordship will not find anything more, then you have to go to the rules. Rule 25. I'll take your lordship straight to the rule. Your lordship has Rule 25, Miller. Every license granted under subsection 1 of section 12 shall be generally generated electronically in form so-and-so of the so-and-so. Every license granted under sub-rule 1 or renewed under 29 shall be subject to the following condition. These conditions are, Miller, kindly turn to Roman 4. The rates of wages payable to the workman by the contractor shall not be less than the rates prescribed under the Minimum Wages Act for such employment where applicable and where the rates have been fixed by agreement, settlement or award or by the appropriate government, not less than the rate so fixed. So this is what is contemplated under the Act and the rules framed thereunder, namely, the rates of wages will be payable to the workman by the contractor, and it shall not be less than the rates prescribed under the Minimum Wages Act. So the bottom line is given in the Act itself. That is the first requirement. And if the rates are fixed by agreement or settlement, we are concerned in this case with the different settlements. So if you have fixed the rates as per settlement, then you will pay according to the terms of the settlement. This is all that is required. Or award, or by the appropriate government, not less than the rates so fixed. So if you have nothing, the minimum is the Minimum Wages Act prescription. Secondly, you may have a settlement, which is the case we have. So I am confining myself to that settlement. So you have to go by the settlement. Then, Milord, the third category now comes. Kindly see 5A. In cases where the workman...
5A, check, rule 5A.
Rule 5A. 25 5A.
Sub-rule 5A.
Yes. In cases where the workman employed by the contractor perform the same or similar kind of work as the workman directly employed by the principal employer of the establishment, the wage rates, holidays, hours of work, and other conditions of service of the workman of the contractor shall be same as applicable to the workman directly employed by the principal employer of the establishment on the same or similar kind of work. This is the third.
So this is what I'm saying.
Yes,
If they are doing similar kind of work as
Correct.
a grade 5
correct.
regular, then they'll have to get the same.
Absolutely right.
Huh.
That is the third mode.
Correct.
Either you have a Minimum Wages Act, second is your settlement wages, third is that claim you can make, namely that we are doing the same and similar work, I am entitled to the regular pay of the regular worker. This is the third option. Now, provided that in the case of any disagreement With regard to the type of work, the same shall be decided by the Deputy Chief Labor Commissioner Central. So this is where, Milord, we are in now. If there is a difference as to whether the contract employees are doing the same or similar work, then the Deputy Chief Labor Commissioner is given the power to decide that dispute.
Correct.
So his jurisdiction is not to prescribe any wages. He has to, in this 5A, he has just to say whether the work done by the contractual employee
To the state.
is the same with that of a regular employee. Suppose he says yes,
Whatever grade that might be.
whatever degree. If he says yes, that they are doing the same work as a regular employee, then the consequences mentioned itself in the in 5A.
Your case is that instead of doing this, he has prescribed the pay scale for what?
Yes, I'll come to that immediately. I'm just proceeding to that end, but I'm trying to show what are the options given in this.
So the first thing is that it should not be below the minimum scale of pay.
First is that,
That's
second,
number two
there is
the
a
settlement.
settlement. Third is, my lord, if there is a
the
claim,
duties are the same, the work.
if there is a claim that we are doing the same work as a regular man, so, and there is a dispute about it between the parties, then the Deputy Chief Labor Commissioner Central will decide whether they are doing the same or similar work. If he says that they are doing the same work, he need not do anything of
He did not,
fixation of,
he did not say that he should be given a certain pay scale.
no, because that is prescribed in the rule itself, 5A. If you say that, yes, this contractual employee and the regular employee, they are doing the same work, then what happens? His decision is to decide whether the claim that they are doing the same work is established or not. If he finds that yes, they are doing the same work, the consequences mentioned in the act, in the rule itself. What it says is, in cases where the workman employed by the contractor perform the same or similar kind of work as the workman directly employed by the principal employer of the establishment. Now, this is the consequence. The wage rates, holidays, hours of work, and other conditions of service of the workman of the contractor shall be the same as applicable to the workman directly employed by the principal employer of the establishment on the same and similar kind of work. So his only jurisdiction, so far as 5A is concerned, is contractual workers make a claim that we are doing the same work, we should get the same wages as the regular employee. And if there is a dispute about it between the nature of the duty, the rule contemplates the Deputy Chief Labor Commissioner to decide that. If he says that yes, they are doing the same thing, the consequence prescribed in the rule itself says that you have to pay the same wages, hours of work, and everything. He doesn't have to decide anything so far as wage is concerned, because wage is already there for the regular employee. If you are doing the same thing, you get this same wages and all the other facilities. So this is the third mode, namely a claim of same and similar work, in which case 5A will apply. If there is a difference between the employer and the contractual employee, the Deputy Labor Commissioner will decide that. And if he says that yes, they are doing the same thing, the consequence is prescribed, and it means that you have to give the same pay and other allowances to the contractual employee. Now, flying to clause B. In other cases, we have got the minimum wage, first case, second case, settlement, third case, same and similar wages. Fourth case is now, in other cases, the wage rates, holidays, hours of work, and conditions of service of the workmen of the contractor shall be such as may be specified in this behalf by the Deputy Chief Labor Commissioner Central. Explanation. While determining the wage rates, holidays, hours of work, and other conditions of service under B above, the Deputy Chief Labor Commissioner Central shall have due regard to the wage rates, holidays, hours of work, and other conditions of service obtaining in similar employments. In other cases is clause B, that means other than these three earlier cases covered under 5A. Minimum wages, settlement, and same and similar work. If there is any other case other than those three types, then B will come in. Then only the Deputy Chief Labor Commissioner has the power to decide the wages itself. Otherwise not. If, my lord, he finds under 5A that the wages, they are working in the same as a regular employee, he should only give that finding, that yes, they are doing the same work. Then the rule takes care of it, the situation, and says that you have to now pay all the thing. In any other case where there is no settlement, there is no same and similar wages, in those cases, the wages have to be fixed by somebody. The bottom line is there. If there is nothing else, the minimum wages will be the prescription. But in any other case, if the wage is not fixed, who will fix it? It will be fixed by the Deputy Chief Labor Commissioner. And what will he do? He will have relevant consideration with regard to wage rates and other things of similar employments. So his right to prescribe a wage comes only under clause B. In other cases, if there is a settlement, you have to go by the settlement. If there is a claim that we are doing the same and similar work, if there is a dispute, he will decide whether they are doing that or not. If he comes to a finding that yes, he is doing, then obviously the consequences in grain. You have to pay the same wages. In all other, apart from that, if nothing of these three are there, in other cases,
So what is your case? That, so,
you have a right to determine the wages.
so your case is,
Now,
there is already a settlement.
correct. We have a settlement not only for this particular year, it has started from 2000 onwards. Periodically,
So when there is a settlement, he could not have applied this B.
correct.
That's your case.
No, not even that. Clause B will come in other cases.
Correct. In other case.
Other cases
after
means
this-
other than the ones
Regular work.
we have taken care of under up to 5A. Minimum wages,
So he has not even gone into the issue of 5A.
5A,
He has overlooked 5A
5A,
and even, and not even the settlement.
correct,
And so he has gone directly to 5B.
correct, correct. So that's
Exactly.
right. That is one. More importantly, my lord, there is a claim here. Same and similar is the claim made by the workers and the union. Therefore, there is a dispute. The company has not agreed. Therefore, there is a dispute and he gets the jurisdiction under 5A to determine who is correct. Are they doing the same work or not? If he says that they are doing it,
But then when you start thinking or you wanting to apply 5A,
yeah.
how can you do it for around thousands of workers? How many workers are involved? You'll have to look at each and every worker's job profile then.
Miller, basically your lordship is right. You have to, there are relevant tests uh, fixed by your lordship as well as the Supreme Court so far as pay parity is concerned. The pay parity, they have said how will you approach this problem? So far as pay parity is concerned, whether you are doing the same work or not. There, the mode of employment, the nature of the work, the expertise which is required, all these factors come into play. Then only you can say whether he is doing the same work or he is not doing the same. His educational skill and all that will come. So if his finding is that they are doing it, then the employees, contractual employees will get the same wages as the regular man. That is mentioned itself under 5A. But if he says that they are not, then if there is a settlement, you go back to the settlement. If there is no settlement, you may come down to B and decide what the wages should be. In our case, there is a settlement. Therefore, if he has found, and I'll show that finding immediately at paragraph page 75, that it is not identical. Your Lordship is aware, Supreme Court has said that it has to be identical, to have the same and similar.
Unless you give me the citations.
I'll immediately give, I have given your Lordship that compilation there. I'll indicate we have given the heading, the pay parity.
What has he done, basically?
That is what I am saying. If he is saying that they are not identical, then
If they're not identical, then he has to come down to 5B.
there is a settlement.
But there's settlement.
Yes.
So question of 5A does not come into play.
No. Because if 5A, if he
5A comes before 5, no, that settlement comes before 5A.
because 5A, if he finds that it is same, then he doesn't have to determine anything. Already there is a wage for the regular man, he will get everything as per the regular scale.
So what has he done?
That is why I am saying, I immediately now take your lordship to page 75. What he has done is, below your lordship recalls, he called 13 from contractual and 14 from contractual and 13 from regular and took their statements. Out of 36 departments, he has visited 8 departments. And then he collects that and he comes to a finding which is at page 75. Three categories are involved in this case below: cleaner, then this medical attendant and helper and security. Kindly turn to page 75, his finding.
Page 75 is your letter.
Impute judgment.
WPC
8150. 8150. 8150.
Yes.
Page 75. Second paragraph. After perusal of the above statements of contract workers and permanent employees, it is a fact that there is no total similarity in the job contents of both types of workmen, but it has also been established that there is a similarity in the job contents of these workmen to a great extent, with a few exceptions. That's his own finding. The contract workers categorized as WCL 1, 2, 3 in the shops and sections like production, oil production, production, telecommunication, electrical material, civil oil, production service are working since long and have acquired sufficient skill and knowledge of their work. They have worked in other shops and sections also, so that they are having varied work experience. They have proved their utility by helping the management in core activities of the company wherever engaged. The permanent employees may have different nomenclatures so far as their designation is concerned, but they are performing almost same type of job as of contract workers. The duty hours of contract workers are same in comparison to permanent employees. It was also observed during the inquiry that permanent employees, although supervising the work of contractor workers, in some cases are also doing the same work as a team, and there is no differentiation in the nature of job of these workmen. The inquiry was conducted on random sampling basis. It has also come to the notice of the authority that there are many field stations of the company where contract laborers are not performing the same job as being done by the permanent employees. So that there cannot be any comparison in respect of the job contents of both types of work.
So basically it's saying that there is some similarity of job in some of the work and in some there's no similarity. So for some, 5A will apply and for some 5B can apply, provided that those cases are not covered by the settlement.
The settlement covers everyone.
Settlement covers everyone.
Therefore, if you don't find, because it is, I'll place these Supreme Court cases, I have cited them, I'll just.
No, so these are questions of fact.
Correct.
Questions
So-
of fact, the question of law does not come in right now. So the question is, Mr. Dasgupta, just one ask. Does the settlement cover all the workers?
No. I have made a elaborate submission on this matter.
This is,
I read about section 30.
saying that,
I'll deal with 13. Okay? There is a difference.
no, I just want to know that, you see, when you go to 25,
Just a minute, let me go through section 30.
30, section 30.
Section
Okay,
30 of
yes,
that.
yes, let us go.
Then I have to argue again. Look.
Naturally, I've got to listen again also.
Then all that. The provisions of this act,
Yes,
shall have effect, notwithstanding anything inconsistent therewith, contained in any other law, or in terms of any agreement, that is settlement, or contract of service, or any standing order applicable to the establishment, whether made or before the commencement of this act. So whatever settlement is there, that will not stand in our way. When the Deputy Labour Commissioner will exercise his power under this act.
the provisions of this act shall have effect, notwithstanding anything inconsistent therewith.
Their case is that we have made certain settlement from time to time. As this settlement was made under the Industrial Dispute Act, it is binding to you all. So now you cannot raise this point. That is their sole case. And second case is that equality, equal wage for equal work has some facets, and these facets are to be complied with. If it is not complied with, then you cannot claim it. That is their case.
for equality, for equal wage is that you should have the qualification criteria, you should have the experience criteria, and you should come through a recruitment process. These are their cases. So as you have not done all these things, so you cannot claim it. That is their simple case, as I have understood by sitting here for a long time.
They are also reading section 12.
Oh, yes. So for section 12 is concerned, it is a grant of license to a contractor.
Correct?
When a license is granted, then some wages has to be fixed.
Under rule 25.
Rule 25. If there are no rule, if there is a dispute, then it should be resolved by the deputy commissioner.
So you are a contractual employee who has come through a contractor. So you are covered by rule 25. Rule 25 says what?
No, let him argue this case, your case, then I will.
No, because I want to clear this part. By the time he finishes his argument, I'll forget this provision. So 25(4) says that the rates payable to the workman by the contractor cannot be less than the rates prescribed under the minimum wages act.
Yes.
Correct?
Yes.
For such employment where applicable and where the rates have been fixed by agreement, settlement over not less than the rates so fixed. So
whatever wage you will give, that should not be less than minimum wage.
correct.
That is one.
So there is a settlement made.
No, listen. Whatever wage you will pay, that should not be less than minimum wage.
Correct.
So who fixed the minimum wage? Government fixed the minimum wages
Correct.
in exercise of their power under the Minimum Wages Act,
Correct.
under section 3 and section 5.
Correct.
So government notifies it. So whatever salary is paid to any employee, it should not be less than minimum wage. It may be more than minimum wages. If it is less than minimum wages, then it will affect Article 23.
No. So right now, it is not your case that the rates fixed by the writ petitioner is less than the minimum wage. It is not your case.
No.
So it is as per the minimum wage or
Yes.
more, maybe.
Yes.
So, but there is a settlement.
Hmm.
Correct? So
Hmm.
this settlement covers your case or not?
No,
Why?
because my case is that we are performing.
You're not a party to the settlement. Is it your case that you're not a party to the settlement?
Even if you have a party to the settlement, well, actually I have forgotten it. It is a long tail case of it. Yesterday I have not gone through it. Gone through it. No.
No. You see, if there is a settlement, a settlement means what? In layman's term, a settlement means an agreed to settlement between the parties. It cannot be a unilateral settlement.
Yes.
Settlement means that.
Settlement means it is an agreement between the two parties.
Correct. So
whether it is whether any agreement made by me with him
yes,
will stand in the way of fixation of wages under 25.
why not? Under rule 12, why not? Why not?
Because I'm also with your lordship.
Correct.
Why not?
So it will stand in the way because once you have settled
Yes.
on the wages, then that will rule the roost.
Yes.
Correct. That will
It
be.
is not only
So when there is
under the Industrial Dispute Act, even it is binding on me.
then end of the matter.
End of the matter. All right. Now your lordship come to section 30. The special provision.
Section 30.
30.
Okay.
I dealt this matter.
No. You see, I'm learning. I'm in the learning stage.
No.
So that's why. Yes.
This is a special provision.
Yes. The provision. Yes. Please read.
No. Let us read slowly. the provisions of this act. Deputy Labor Commissioner is
Shall
exercising,
have effect.
the Deputy Labor Commissioner is exercising his provision under this act.
Correct?
So, the provisions of this act shall have effect, notwithstanding anything
Notwithstanding anything.
inconsistent therewith contained in any other law.
Correct?
For the timing, let us hold.
Correct?
Now, your lordship, come to the Industrial Dispute Act. Industrial Dispute Act says, and you not give it, let me give it. Industrial Dispute Act says when there is a settlement, it is binding.
Correct?
So, you have made a settlement, so you cannot go away.
Correct?
In view of the provision of the Industrial Dispute Act,
Correct?
you have made an agreement,
Correct?
you cannot go away.
Correct?
In view of the Contract Act.
Correct? Correct?
So I don't have a case. The case is in his favor, entire case. If I go, because there is a settlement.
You see, if there is a settlement between you two, you are bound by the settlement.
Yes, I am bound by the settlement. That's for Industrial Dispute Act.
So
But when we are dealing with the provisions of provisions of the Contract Labor Regulation and Abolition Act, there is a special provision.
that means
That
you
special
can
provision is
that
there,
special-
not inconsistent with any agreement or any law.
So then so there is nothing inconsistent here. When you have settled an amount and when you have made a settlement, what is the
Yes,
inconsistency?
inconsistent is with regard to the Rule 25.
How is it inconsistent?
Because I am performing same and similar job.
Huh?
We are performing same and similar job. For that purpose, we are entitled to have the similar wages.
I will give that order. I will give that order. I will give that order as you have said it. Since you have made a settlement and since you are eligible to have the same wages as per the similarity of jobs as mentioned in 25
That is, your lordship need not give it. The Deputy Labor Commissioner himself gave it. He made an assessment.
Correct. Now, so that is why when 25A is already there, 25(5)A is already there. And not only that, 25(4) also has been also incorporated. What he's saying is that 25(5)B cannot be invoked.
But yeah, it is his innovation.
That is also your submission. This entire submission of yours, that
Submission.
you are agreeing with the submission.
On the last occasion, I have made my submission in detail, but then I have to again reopen it. Let him conclude with this thing.
No, that is what he's saying. Long and short of
All
what,
right, let him conclude.
long and short of what he's saying.
No,
Also, yeah.
utmost request, let him finish it back together.
No, he's finished. For the time being, he's finished. Huh? Oh, proviso. Let's go to the
Provided that where any such agreement, contract of service or standing order, the contract labor employed in the establishment are entitled to benefits in respect of any matter which are more favorable. One thing is that which are more favorable than to those to which they would be entitled to under this act. The contract labor shall continue to be entitled to the more favorable benefits in respect of that matter, notwithstanding that they receive any benefit in respect to the matter under this act.
Correct.
So, one settlement may give some benefit, whether this benefit is more beneficial or not.
Now you tell me, which is the more beneficial?
Be-
You show me that.
Deputy Labor Commissioner order is more beneficial.
No. Those more beneficial may come into play only if 25(4) is not there and 25(5)A is not there. Then maybe under 25(5)B, he can come into this more beneficial aspect. You cannot bypass the rule 25(4) and 25(5)B, 5A.
25?
Rule 25, 5, Rule 25, 4. Sub Rule 4, and thereafter Rule 25, 5A.
Rule 25, 25, 5. A.
Yeah. You see, Rule 25 will have to be read in conjunction with Section 12, if I'm not mistaken, correct?
Hmm.
So,
Yes.
so it's only then when these two do not come into play that maybe you can use 25.5, Rule 25.5B. But that also, I do not know how the proviso to Section 30 comes into play. Because you'll have to show that there is some other beneficial benefits that you can get
No,
beyond
his
beyond this act.
That is his burden, Lord.
That is your burden.
No,
That is your he wants to give you as less as he can. He wants to give you minimum. You want maximum. So you'll have to show that you can get some benefit beyond 25, Rule 25.
yeah, that has been dealt with by the imperial order itself.
That is maybe what is challenging.
That is his challenge.
So
the
you'll have
imperial order, by the
so you'll have to justify how can this person, this authority, apply the proviso to 30 without there being anything to show that there is some that you're entitled to benefit which are more favorable and beyond
Yes, that is indicated.
beyond this
That is what-
acts and rule of
that is
1970.
indicated in the imperial order itself.
No, if you no, how? You see, it is a provided that
Well, let me let. If your lordship remember the content of the imperial order, your lordship will find the so-called the amount determined by the deputy legal commissioner is concerned. That is far above than the settlement.
correct, but can he do that? Can he do that?
Because
Can he do that by bypassing Rule 25?
Rule 25?
Rule 25. Rule 25, sub clause 4, sub rule 4.
The rates, wages payable to the workman by the contractor shall not be less than prescribed rate of minimum wages. That is no problem.
Carry on.
Act. Minimum wage. For such employment where is available, where the rates have been fixed by the agreement, settlement, or award by any appropriate government, laws not less than the rates so fixed. where for such employment where the applicable and where rates have been fixed by any agreement, settlement, or award by the appropriate government, laws than the so fixed. So what was the raised wages payable? Minimum wage fixes any rate which is required to be paid to a worker. Minimum rate. So any salary you propose to give any person, it should not be less than the minimum. It should be always above than the minimum.
Can you show that that the rates you're getting are less than the minimum wage?
No, it is admitted position, it is more than the minimum wage.
Then
More than the minimum, no problem. You must pay wages more than the minimum wage or at
par.
So if it is more than the minimum wages, then whether it is in accordance with the Rule 25 or not. This is simple question, Milord.
Correct. Correct,
person should not get less than minimum wage.
correct.
Now, I am giving some wage to my employee. It must be more than a minimum wages or at per minimum wages. Now let me assume that I am giving minimum wage, my wages above than the minimum wages. All right. So whether these wages which I am giving to my employee is in terms of the provisions as contained in the Contract Labor Regulation and Abolition Act
And the rules made there.
and the rules made thereunder and published. If it is not so, then what will happen?
They are saying it is so.
All right. If it is not so, then
No,
what will
if-
happen?
If it is not so, then you have got a
They
case.
are saying, they are contention,
you
it is
show-
so.
But you have got to show, they have shown
No,
that it is so.
no, they are contention, it is so. Why? We have our settlement. We made some certain settlement,
Correct.
and this settlement is binding. Now you cannot raise any question according to them. Now you cannot raise any question.
You can raise question.
Let me go by their submission. We have our settlement and it is binding on you. Now you cannot raise any question. All right. So whether it is correct or not. Now, section 30 says, even there is any settlement which is inconsistent with the wages, then also these provisions of these wages
But
are
where is the inconsistency?
because the wage payable paid by them is less than the wage paid to the contract laborer, principal employees of the principal employer who is discharging same or similar debt. That is simple as good as.
Okay, so in that case,
Yes.
what they are saying is, then
Let them say what they say. That
No.
is one thing.
no, please listen. Then the issue is, in that case, 25(5)(a) will come into the picture.
No.
Why not?
That can be.
That is what.
25 is simple.
Please read 25(5)(a).
Let me give you. 25 is simple. Whenever any employer pays his wages to his employee, his payment should not be less than minimum wage.
Correct. And
That's
then
what
if that is not, and then if there is a settlement, it should be paid as per the settlement,
At last settlement.
as long as it is not less than
Right.
the minimum
If
wage.
there is a settlement, you should pay.
Supposing,
As there is a settlement, you should pay at the settlement, but this settlement should not be less than the minimum wage.
correct.
It must be above minimum wage.
Correct.
All right, there is no problem.
Now,
Now,
if
what-
there, supposing
now,
there
let me
is a
say.
settlement which is inconsistent.
No, let me say. Now they are saying, yeah, we have made our settlement and our settlement paid, what we are paying is far more than minimum wages.
Correct.
So you cannot raise this question.
Correct.
All right.
Hmm.
Now, all right, let me assume that their settlement gives us more than minimum wages. In fact, now whether these wages is in terms of the Contract Labor Regulation and Abolition Act and the rules framed thereunder. What is that?
They are saying it is.
What is this content? Content is that when a contract labor performs same and similar nature of job, then that contract labor is entitled to have same and similar wages as being paid to the employee of the principal employee.
Correct. I
Now
agree
the
with you.
Deputy Labor Commissioner has made an assessment.
No. So that is where
Let me finish. Now the Deputy Labor Commissioner has made an assessment
Of
and
what
according
should
to
get.
his assessment, the contract laborers are getting far below the wages that are being paid to the principal employee.
Okay, so we will say that as long as there is a finding that they are doing similar kind of job,
Yes,
they will get similar pay. That's all.
that is absolute.
That's all.
Yes,
So
that is the
now
case.
that is the only thing.
That is the only thing.
Now the only question is what you were submitting was with regard to Rule 25(5)(a).
Hmm.
That is what exactly 25(5)(a) says. Only thing is that the Rule 25(5)(a) does not contemplate the commissioner to say that, to quantify the pay or salary, whatever, if that is to be given, but only has to say that if they're doing the similar kind of work, they shall be given the similar pay and benefit.
Simple question is that any workman should not get minimum wage, less than minimum wage.
Correct. No, you please read Rule 25(5)(a).
Yes, sir, I'm very reading. Last 40 years I am reading English.
No. So, so you see, what they are saying is that he cannot fix the wages because the wages are already there. He has only got to say that they are doing similar work.
No, he shall fix this work.
Please read.
Hold. Let me for the timing, your lordship may kindly excuse me to get rid of 25A. I will come it again.
Yes,
Let us
sure.
read class 4. Twenty-five.
25(5)(a).
Let us for the timing skip of 45A. I will come again.
That is the question
I'm-
I'm putting to you. That is what I want to know.
I'm come again.
You see, I'm not-
all right, let me read 5A. 25(5)A.
Yeah.
All right. What was it? Oh. Let me read again 25(5)A as you all desire.
Yes.
Now, a person is working certain establishment.
Correct.
He is entitled to some wages.
Correct.
So what will be his wage?
Correct.
Law says that whatever wage you pay, it should not be less than minimum wage.
Correct. Correct.
Who will determine the minimum wage?
That-
Minimum wage will be
Correct.
determined by the government.
Correct.
I fix these minimum wages and you should not pay less than minimum.
Correct.
Now, in what manner I can pay the wages? That is the thing.
Correct.
I can pay wages by making a settlement.
Correct.
I can pay my wages by through my standing order.
Correct.
So whatever the mode of payment, whether it is standing order or whether it is
Settlement.
settlement, it should not go less than this.
Correct.
This is simple
Correct.
thing
Correct.
that has been stated in 25A.
Correct.
Now let's come to 25B.
No, 25(a).
Huh.
No. Yeah, no. Please read 25(a). The problem is you're
No,
not
no,
reading
I-
25(a).
I'm reading it.
You have read 25(4). You have not read 25(5)(a).
Then let me,
25(a). Please read.
in case where the workman employer, I'm not, don't think that I'm skipping up.
No. I'm just asking.
I'm not skipping up.
Correct. Please read.
I'm not avoiding it. In case where the workman employed by the contractor means a employer employs a workman. All right.
When a contractor employs a work, contractor gives the workman for the principal contractor.
All right. Where the workman employed by a contractor
Yes.
means a contractor employs some person for the job of
Principal employer.
principal
For
employer.
the principal employer.
For the principal employer. Is this much correct?
Yes, correct.
Gotcha. Perform same or similar kind of work.
Correct.
Same or similar kind of work
Correct.
as the workman directly employed by the principal employer
Correct.
of the establishment.
Correct.
This much correct?
Correct.
Now then what will be happen?
Correct. Will happen.
What will happen? That is the question.
Correct.
Meaning that three condition. I have selected a contractor. You please employ your employee for my job.
This
And
25(5)(a) is going to support your submission. Please read it in full.
Uh,
Please read it in full. It is in your support.
Yes, my support.
Read it in full.
the wage rates, holidays of works and other condition of service of the workman of the contractor shall be the same applicable to the workman directly employed by the principal employer.
Correct.
So what's the harm of it?
That's what I'm saying. This is supporting you.
You, me,
Please read it.
employer of the establishment on the same and similar kind of work.
Correct. So this, so it says
Hmm.
the workman employed by the contractor, as long as they do the same work as the regular employees of Oil India, will get the same
Same work.
pay and everything.
Same one.
Ah.
Now, again, provided in case of any disagreement, say
Yes.
the contractor does not agree with this,
Correct.
I will not pay this.
Correct. Correct. Does not agree that it is same kind of work.
I will not. With regard to the type of work,
Ah.
because contractor may say, no, these employees, my employee is not doing the same job or similar job or identical job as being performed by the
Correct. Correct.
principal employee.
Correct.
So why should I pay?
Correct.
I will not pay. Provided that in case of any disagreement with regard to the type of work,
Yes.
disagreement with regard to the type of work,
Yes.
it should be remembered. The same shall be decided
Correct.
by the Deputy Chief Labor Commissioner.
Correct.
And what he has done, he has decided.
That
Yeah.
is what. Now the thing is that he has to decide what? He has to decide whether the type of work is the same or not.
Yes. So what your lordship want, yes, now I have gotten it. What your lordship want to say, that his duty is to decide, not to fix.
Not to fix.
That is
That is
simple,
that is
simple question.
Yes.
Now your lordship come to
now what has the commissioner done in this case?
section 12,
No, section 12.
section 12.
So
Yes, now I have understood what your lordship's query. What your lordship want to say, yes, he may exercise his power under the rule, but while exercising such power, his duty is to pronounce that these people are doing the same
Same
nature
type of
of
work.
job and nothing else.
yes,
This is,
because if he says that they are doing the same type of work,
Yep.
automatically
he will
that
get it.
they will get.
Yes, that is correct. Yeah. Now your lordship anxiety, I found one so long without, your lordship anxiety is whether he can fix it. What your lordship wanted to say, yeah, he can declare it. Yeah, you see, these are the person who are performing same nature of job. This much you can do, but you cannot fix their wages. It is not your duty. The act
Because it is
has not authorized to do this.
because it is already fixed.
That is already fixed.
Fixed by the Oil India for their permanent employees.
Certainly. So he is to declare that these are the person, identify, these are the person
Doing
who-
similar type
similar
of
type of job. And they are entitled to the same job.
same pay as the regular employee.
Yes. And that is what he has done.
Let us ask him that. Let us ask him that if he has done that or not. Let us see what he has done. Yes. I think we have agreed now to that point.
Yes. That is,
So the only issue is
yes.
whether the Labour Commissioner has done as per 25(5)(a). That is whether he has decided that they have done similar work or he has gone beyond that. So just tell us.
That's what I was on.
I know. But I just wanted to clarify.
Yes, correct.
In this part, we all agree, I think.
Yes.
If I say we all agree.
I mean, I was placing 75, right?
Yes.
If he had recorded a finding that they are doing the same and similar work as a regular employee, the consequence would automatically follow from 25A itself.
Correct?
In that event, he did not add any amount or anything.
Hmm.
The wages which are being paid, the hours of work and everything will be a same that is mentioned in 25A itself.
But what is the finding?
That is why the problem is, he says at page 75 that
There is no total similarity.
similarity. That is the whole problem. And why is it, what has he done after that? Kindly turn to page 80. After recording that fact, that it is not identical,
Yes.
it has to be identical. I have cited two judgments of the Supreme Court.
I don't.
I'll just say it, I'll show it again. But kindly turn to page 80. He is also conscious that he is not doing what the act contemplates. Namely, if he has said that it is the same and similar work, he need not do what he has done. He has just to say that yes, they are doing the same and similar work. The consequence is obvious because the rule itself says that in that event, all the facilities, all the wages, hours of work, everything will be as that of a regular employee. That is inbuilt in 5A.
No,
But what has he done? Kindly see.
Yes.
After recording that finding, and kindly turn to page 80, which is the operative part of the order.
Yes.
Last point. In view of the above, the contract workers categorized as WCL 1, 2, 3 engaged by All India mentioned in the application of the union and in respect of whom an inquiry has been conducted by the authority under Rule 25(2)(5)A of Contract Labor Rules 71 have been found to be performing
The same and similar kind of
to
work.
the work as of regular employees of the company for pretty long time. Hence, their monthly wages should be commensurate with the volume of work, hours of work, weekly off, and other conditions of service with a view to bring about parity in comparison to regular employees to the possible extent. As such, the wages of these contract laborers, known as WCL 1, 2, 3, is fixed
In the following
in
month.
the following manner. Now, what does he do? Kindly turn to security guard 1. 27,600 wages fixed on monthly basis.
So first of all, there's a contradiction between page 75 and page 80.
Absolutely. I'm showing that he is, if he had done that, since I have held that they are
If
doing
it
the
is,
same.
if it was done as per page 75, it was all right.
Correct, Milord. If he came to a finding that they are doing the same work as the regular employee, he need
need
not
not
do
make
anything
this.
else. The Rule 5A itself has the inbuilt consequence.
Correct. So no, so
What is it? What does it do at page 80?
has done this.
Let's see.
no, I get it.
Now he says, security guard, wages fixed on monthly basis. Now he's fixing the wages.
Okay.
27,629
Plus 5,000.
plus 5,000, 32,629. Where does he get 27,629? Kindly turn to page 58. Kindly see at page 58, pay scale of tradesman or attendant of grade 1 and other allowances. Grade 1 is the lowest. Regular employee. He is,
It is their document.
total is 27,629. So he, at page 80, he starts with 27
and add another 5,000.
And another 5,000. And it is 32,600.
Okay, so everywhere there is an addition basically.
Addition.
Except for security guard WCL 3.
No, that is also there. The next page, below page 59.
এই সময়ত সিহঁতে ইমান বেছি প্ৰথমতে ইটোৰ লগত ইটো সমান কৰি ল'লে কৰি কিনে আৰু এডিশ্যন খাই কিন্তু
If your lordship sees at page 59,
লিষ্টেড ওৱান
listed,
What do you mean by listed 1, 2, 3?
listed 1, 2, and 3. Listed 1 and 2 and 3, because your lordship will recall they have their settlements, where they mention about WCL 1, 2, and 3.
Ah,
Basically, below, this is a description pre-2000
ah,
and post-2000.
okay.
And that nomenclature earlier was different. And in one of the settlements, they have.
So outer is 27,629. Outer, how much should it be?
Because pardon?
In page 80,
Yes,
serial number 3
yes,
is 27,629.
yes, that your lordship will get at page,
59
page 59.
59
59? Where? Which room?
থাৰ্ড
Listed
No, no.
3.
যিটো কাৰণ
No, below this security guard,
সিহঁতক ডাইৰেক্টলি ভৰাই দিলে 10,000
27,629.
Where do you get this?
No, he is giving this. Now, page 58 and 59 kindly turn.
Ah,
Regular employees, what do they get?
এতিয়া ইটোক তাৰমানে প্ৰথমে প্লাছ কৰি দিছে
Kindly turn to page 59.
hmm. Listed 1 get
WCL
26.
Listed 3. HRA so-and-so, basic so-and-so, and total is below 16,988.
Correct.
That was the amount the regular employees getting.
Okay, this listed 3 is what? Prior to or what?
after
After,
After what?
2000
2000.
2000.
Ah.
And listed 2?
listed to prior and after
Prior to listed 1?
listed one prior to 2000
2000.
What's
These
there?
are only
So,
for identifying.
Anyway, so
Only for
so
identification.
basically,
Now, what is important is below at page 59, the total amount for listed 3 is 16,998.
Correct.
Contact.
58.
correct.
Now kindly turn to page 80,
It's 27,000.
27,629. So it is an increase of 16,000 from 16,000 to 27,629,
almost 10,000
almost 10,000 increase.
similarly
So he is not getting what the regular security man is getting. He is getting more than him by this addition.
But now I think the pay scale will all be different.
Now it is different. Now, Milord, I will give you a lordship the broad figures. The last settlement increased the rates. So now this kind of workers are getting about,
46.
what if they have signed the agreement, there was a clause in the agreement that you have to sign the agreement,
136
136. Then, Milord, they are getting about 46,000 and all. Now, if they have not signed,
now
they are getting 39,000 and all.
I think
Now, your lordship should remember a case where an application was moved before your lordship by a group of people.
they wanted to join the settlement.
They wanted to join because they were losing 7,000 every month. And your lordship sent them there that you file there and see.
Right.
Because of
And they have filed there.
Huh?
case is going on for.
No, that is right, all right. But they have gone back.
2017.
The dream of,
So, all right, it's all right. What to
the dream shown by them has vanished. So they went back and filed an application and signed the agreement.
Okay.
And the company has.
So the long and short of your argument now
Ah,
is basically since a decision has been made in terms of page 80, which is not really in consonance with page 75. But since it is made as per 25(5)(a), so the benefits payable to the contractors' employees would be as per 25(5).
It is more than that.
No, now, of course, settlement.
That's what I'm saying.
No, but then, no, there is some disconnect here. Why are you not agreeing to them? I don't understand. There's the other side. I think Mr. Das Gupta, you're missing something, or am I missing something? Yes, Mr. Goswami, why then, am I missing something here?
No,
Why is there some opposition to this?
I don't know, Milord.
There must be something.
Yes, yes, that's why-
That is-
let him say, I will, yeah.
সিহঁতক
That will come out from the back.
Cat will come out from the back. It's high time it comes out because I'm still missing with the
Yes.
point that means.
আপনি কই যাবেন? না, একজন বলুন।
No, kindly turn to page 59.
Page 59.
Yes.
No, what is that? Again, the same thing.
প্ৰথমতে ইটোৰ লগত ইটো প্ৰথম সমান কৰি লৈছে তাৰপিছত 5,000 এডিশ্যন দিছে ইটো কৈ যাওক প্ৰথমতে কিটো
Milord, kindly see listed one, for example,
Yes.
26,597.
Correct. And out here, page 80, it is 27.
No, no, they are getting 27,629,
That's what I'm saying, 27.
correct? Because he has added, Milord, 1,032 to 26,272 first. He has added something more.
Yeah.
And then he gets that figure of
I
27.
know, he's added something.
In addition to 27,
What I'm trying to find out is, why are they opposing this, your submission? There must be something I'm missing. There must be something I'm missing.
I am
Say I'm perfectly agreeing with you right now,
I am
but why they opposing it, I don't know.
placing the Act and the rules and the judgment. I have not hidden anything from your lordship.
No, or am I missing something, or
No, your lordship is
they
not missing.
have not
But
brought
I
up
am-
the
I am
entire
trying
thing?
to explain
Uh,
what he has done.
no, that I've got it.
He has
What-
not only the,
No, Mr. Goswami, basically is this. Your case is 25(5)(a) has been applied, wrongly applied. Meaning to say, he has agreed that they are similar work, but he has made the salary payable in terms of 25(5)(b). Though 25(5) has already settled the issue.
correct, Milord, that is,
And in fact, more than that, there's already settlement.
yes, that is what I am saying, that what he has done, Milord.
What?
No, Milord, may I
Ah.
make this clear? If your lordship sees page 59, the amount is 26,597.
Correct. I got
No.
it. And out is 27.
Then, Milord, he adds there
Yeah,
to reach
but-
below 27,629.
yeah.
And then add 5,000, 3,000, and so far as the third category is listed 27,629, which they were getting only 16,998 at page 58 and 59, that addition of 10,000 to reach this. Now, where does he get this jurisdiction?
Under 25(5)(b).
Correct, but the
25(5)(b) that cannot be applied
kind of-
because of 25(4)
Ah.
and 25(5)(a).
Correct. And
That is the
view of his own finding, he cannot apply the same and similar payment. That finding is not that it is same and similar.
and that is in page 75.
Page 75.
So page 75 and page 80
He says
have
that
variance with each other.
he says that they have acquired experience, they have long service. All right, but for experience, you don't get it.
So if he was going to take a final decision
Huh,
as per page 75,
huh.
then he could have applied 25(5)(b).
No, because there is a settlement in this case.
Other settlement.
Huh? So because below, if I have a settlement.
If there was no settlement,
Ah.
then 25(5)(b) could have
Could
been
have
applied.
been, could have been,
Could have been applied
Ah.
if we are to rely upon his findings in page 75.
correct.
But since he has made a finding again in page 80,
Ah.
which is at variance with page 75,
Ah.
then 25(5)(a) would have to be applied as per page 80.
Correct, because he has done,
But that is also will only come into play if
5P.
that settlement is not there.
if he has exercised power under 525(5)(b), he could have done all these additions, otherwise not.
Yes, there is Mr. Das Gupta. Anything else to decide?
Section 18, if your lordship recall, I have placed section 18 of the Industrial Disputes Act.
Why? For what purpose?
Because settlement is arrived at, and once it is arrived at, the consequence is, it covers all existing workers and those who will be coming in. Because it is a very special provision for conciliation settlements. Normally, my lord, if it is an agreement, it will not have that impact. But if it is a settlement under the Industrial Disputes Act, then the consequence is prescribed in section 18(3). And Supreme Court has said that these conciliations stand on a higher pedestal and just like an award. So the idea that 18(3) is best is that if you have a conciliation settlement, this is not only given to the persons or the unions which has signed the agreement, but it covers all the other employees who are working. Not only that, but who will come and join.
So it means that the settlement made under 18,
Huh.
does it mean that all the unions need not be there?
No,
They don't-
even if they are not there, the members will be covered. You kindly see section 18 for a minute. Kindly see, it's a very.
Yes, not section 18. But again, you are not completing your argument. Again, that is the problem. And again, I'll forget.
That is the problem, Lord.
No, the problem is
No, so far, I just know, so far the settlement is concerned, right now, your lordship asked me, that I incurred this matter. If we have to abide by the settlement, then we will not get the number of facilities which we are entitled under the rules. Those facilities are mainly medical treatment, medical facility, that we shall not get. Housing.
In the settlement, it is there.
Holidays, holidays,
Holiday,
leave.
everything is covered.
Oh, let me see. Leave. Holidays as per, as per the regulatory.
just write down. Just write down. He says, you said medical
Medical
facility. Number two,
Housing,
number two is leave.
leave,
Number three is housing. Then
holidays,
holidays.
holidays,
Then what else?
leave.
Then what else?
Right now they have some, there are others.
So we will see the settlement.
Yes.
We'll see the settlement.
Yeah.
You see, if
No.
it is, wherever the settlement does not cover, we'll apply 25(5)(a).
Yes. Yes.
Let us
Yes.
go slowly, kindly see first
Yes.
18(a).
Allah, that is, yes, that is.
I'm in a hurry because I'm going to forget soon. You are going to again argue some other day.
No, your lordship won't forget.
Yes, that is.
18.
Kindly see section 18 first.
Yeah.
A settlement arrived at by agreement between the employer and the workman, otherwise than in the course of conciliation procedures,
Holidays as per contract level, principal level.
shall be on the binding on the parties to the agreement, first clause. It is only, if it is an agreement, it will be binding on the party.
Not in the course of a conciliation
Subject
proceeding.
to subsection 2, subject to the provisions of subsection 3, an arbitration award which has become enforceable shall be binding on the parties to the agreement who have part the dispute. Right? 3 is our important provision.
Okay.
A settlement arrived in the course of conciliation proceedings under this act, or an arbitration award in a case where a notification has been issued under subsection 3A of section 10A, or an award of a lower court, tribunal or national tribunal which has become enforceable, shall be binding on all parties to the industrial dispute, all other parties summoned to appear in the proceedings as parties to the dispute unless the board, labor court, tribunal, as the case may be, records the opinion that they are so summoned without proper cause. Where a party referred to in clause A or B is an employer, his heir, successor, assigns in respect of the establishment to which the dispute relates. D, where a party referred to in clause A or B is composed of workmen, all persons who were employed in the establishment or part of the establishment as the case may be, to which the dispute relates on the date of the dispute, and all persons who subsequently become employed.
So do you mean that all the contractors were part of the settlement also?
It's a settlement with the union.
With the union?
Which
Were
regard
the contractors a part of it?
No, it is
They're
the
not-
employer who is, principal employer is a party and the contractor, the unions are parties.
Contractor is not required to be a party.
They were not, they didn't sign because they are bound by the terms of the settlement. Because the wages have to be paid by them as per the settlement.
So it's a settlement made between principal
Yes,
employer
yes,
and workman.
if they fail,
Contractor is not required.
no.
The person who is to give the payment is not required to be a party.
Yes.
He may or may not, because, the principal employer is a party. Oil India has to ultimately pay to the contractor. If he defaults, he has to pay to the workers also. The lordship has seen that provision, carried out. So there is no difficulty about that.
No, I just want to know
Yeah.
what is the liability of a contractor?
Liability of the contractor is to pay the wages.
Pay the
for
wages, but when
settlement.
he is not a party to the settlement,
It doesn't matter because he is paid by the principal employer for the wages he pays to the workers.
okay.
That is the thing. And if he fails, the principal employer is required to pay. I have read out that provision. Last settlement, there is the contractor even is a party.
Contractor is a party.
Yeah, the present settlement which is one. So 18(3) clearly specifies, and there are Supreme Court cases which I cited, I'll just give your lordship phrase, that this is the position, legal position. Because it will not only be, that is why Supreme Court has used the expression splinter groups cannot be allowed to disturb the settlement arrived at during the course of the conciliation. Because these settlements, some of these settlements, about 5 or 4 unions are signing. Last agreement, about 5 unions have been signing. They're all comprehensive. Suppose a splinter group comes and this union comes from Gujarat and tries to create a situation here. And then, it says that if you are coming here, splinter groups cannot be allowed.
So basically, again, you are agreed with page 80. Page 80.
Yes. He is finding, if he has to say that the same wages will be paid as a regular employee to the contract laborers, then he has to record a finding by taking the relevant test as laid down by your lordships and the Supreme Court, namely the parameters which are necessary to be considered. By following that, if he comes to a conclusion that they are doing the same work, then the consequence prescribed under the A will come. But if they are not, if he is not categorical about his finding, you cannot burden the employer with this much of wages.
So your argument is
Huh.
that first of all, there is a settlement.
Yeah,
So settlement has to prevail.
yeah.
Number two,
Settlement is for the contract laborers.
huh?
For the contract
told
laborers.
you. So number two, even for coming to a finding under 5A,
Yeah.
he has to follow the guidelines laid down by the Supreme Court
Huh.
to come to this to take a decision as to whether they are doing similar kind of work,
Very.
parity of work.
Hmm.
That has not been done.
None.
So, and then third limb of the argument is there is, of course, though there is a disconnect between 75 and page 80.
Yeah.
Since he has finally come to a finding that there is parity of work.
No, he has not given a categorical finding. that they are doing the
Particular
same.
general finding.
In the absence of a finding of that nature, you cannot do what you have done.
No, and even if he
Huh.
came to a finding,
Huh.
he
He
could
need
not have done the same.
do anything about wages.
He could not have made a separate wage structure.
He cannot. It will, obviously it will come from the 5A itself. Therefore, this is a absolute necessity that while dealing with this,
So what should be done now? So now, how did it go to this commissioner? This issue.
they file an application and he issued
Application for what?
for raising this demand for same and similar
Pay.
pay. Then the process started. And then
A conciliation proceeding was held.
uh,
Conciliation proceedings were held.
no, he is the authority who will decide that.
Acha, under this
Under this 5A.
contract labor
Ah,
act. Okay.
25,
Ah.
5A. If it is that claim, and if there is a dispute, he is the authority.
So he decided it
Ah.
straight away.
And that is a quasi-judicial authority. You can't take just like that. You have to take evidence. What has he done? He goes 8 to 8 departments out of 36, calls 13 and 14 from 2 group, takes their statements and passes an award.
So what should be done now? We should set it aside and send it back to him or what?
Don't know what he wants.
No, what do you want?
What do you?
You're the representative.
Milord, I leave it to your lordship, but this.
No, what do you
cannot
want? What
stay.
is your prayer here?
The order can't stand.
That is one. What should be the consequences of that? What do you want at the end of the day?
Leaving to us, Milord, who would like to have an end to it because they are getting.
That is all right.
Ah.
End to it.
Ah.
Meaning to say, what is the final decision that you want made from this court?
To set aside this order.
That's all.
Ah,
To set aside the
ah,
order. And
simple. And because then,
and
Milord,
so and that everything should be
as per
should
the settlement.
as per the settlement. That's all.
And now it has become far more after the last.
So we'll be benefited.
Huh?
We'll be benefited.
46,000.
So you tell me, what do you want?
Whether he has concluded
He has concluded for the time being.
40 times.
all the time being.
Hmm.
That is
We have got
That is the problem. That is the problem. Now first comes settlement. Whether this settlement is the binding on us. This is no initial dispute person. What is the settlement?
No, not that. Milord, he was mentioning about some allowances. His terms of settlement
Agrees all, as all.
include
Yes, yes, I have done through.
include everything.
Yes,
In
yes,
the
I-
latest,
Yes.
your lordship will get at page 136. It
Yes.
starts. No? 137, your lordships will get the
Not-
basic pay, the core allowances, DNS allowances,
Holidays, leave.
Yes.
Oh, yes, yes.
House-
That is not,
house
Yes, that is-
medical allowances, special
Housing-
allowances,
housing-
increment. Yes, Milord.
that is not at part, that is not at part of
Housing-
the principal employer, simply.
Halting allowances.
Not as par with.
The benefit is that,
Statutory
that is
benefits.
getting the employees of the principal employer.
Overtime,
We have
gratuity, ex gratia, leave holidays, casual leave. Leave with wages,
Yes, yes, all that.
maternity leave, special leave with pay, holidays, other facilities,
It should be at par with the holiday facilities level.
age relaxation, funeral.
Okay, one thing, Mr. Goswami.
Ah.
Now he's taking a plea that the settlement made the settlement made and the benefits under the settlement is not at par
Yes,
with the benefits given to the regular employee.
yes.
Now, can that be a reason for the commissioner to apply 25(5)(a)?
Yes.
This, if you have not challenged, as a union, if you are trying to raise this dispute, you have to raise a dispute.
No, no. You see, because
Because there is a
it
settlement.
is
in our-
settlement has been made.
This settlement.
Settlement has been made.
Ah.
Now they're bound by the settlement, no doubt. But later on,
Hmm.
they find that they had not given due application of mind while making the
They
settlement.
should.
But
do-
now,
Hmm.
there is a dichotomy between 25(4) regarding the settlement and the benefits under 25(5)(a).
Hmm.
Why shouldn't they get the benefits as per 25(5)(a)?
Yes.
Rule
No,
25(5)(a).
which benefit, you know?
Benefits, all benefits.
No,
you see, Let us see 25(5), Rule 25(5)(a).
And section
Just a
30.
minute, just a minute. Yes. Rule 25(5)(a) says,
Correct.
in cases where the workman employed by the contractor perform the same or similar kind of work as the workman directly employed by the principal contractor employer, the wage rates, holidays, hours of work, and
Yes.
other conditions of service
Yes.
shall be the same.
Only medical allowance, holidays, housing allowance. All these things will include. Holiday.
In cases where the workman employed by the contractor perform the same or similar kind of work as the workman directly employed by the principal employer of the establishment. It is a conditional thing.
Correct.
The
Condition.
wage rates, holidays, hours of work, and other conditions of service of the workman of the contractor shall be the same as applicable to the workman directly employed by the principal employer of the establishment on the same or similar kind of work. Now, I am not sure, Milord, as to what is the difference which is there. I'm sorry, Milord.
No, supposing there is a difference. Supposing there is a difference.
What kind of a difference we
Hey,
have to assert in?
No, supposing there is a difference in the housing. Supposing one is getting a type 2 and one is getting a
No,
no,
it is
I do not know.
like that.
Medical
Even-
facilities,
Or medical facilities, or supposing there is a difference
holidays.
between the
Wage
settlement made.
rates, holidays, hours of works, and other conditions of service of the workman of the contractor shall be same as applicable to the workman directly employed by the principal employer of the establishment on the same and similar kind of work. So this is, if he does the same work,
Correct.
which is not defined.
Same or similar?
Similar work,
Same or similar?
same or similar, that is not even the finding. If that finding comes below, the consequence is clear.
Then this will supersede the settlement. Will it supersede the settlement? The benefits given under the settlement?
Milord, if the authority concerned, after taking the relevant tests into account, records the finding that these contract laborers are working as the
Regular
other
workers.
regular workers are working, then these consequences will follow.
Will follow,
Huh.
even if it is
Huh.
not in
And,
of the
and
settlement.
what is the consequence? Wage rates, holidays, hours of work, and other conditions of service of the contractor shall be the same as applicable to the workman directly. And
So my question is
Yes.
again, if there is a difference
Hmm.
in under these parameters,
Hmm.
under the settlement,
Hmm.
and as per the actual benefits given
Hmm.
to the regular workman,
Hmm.
will 25(5)(a)
Hmm.
supersede the terms of the settlement to the extent indicated here?
Milord, if they are doing the same work, obviously.
So that is what.
But if that finding is not there, then we cannot import this clause partially. That is the whole difficulty.
Correct. No,
Because
but
then the settlement,
so
one of the modes is settlement. So settlement is there. So long you don't avoid the settlement, that question will come only if a proper judgment is given, taking into account the relevant tests and applying the same and say that it is identical.
no. The word identical is not here.
Milord, two judgments I have cited.
You have cited, but with regard to this 25(5)(a), it does not talk of identical works. It talks of
Same
same
is
or
similar.
similar. Similar does not mean identical.
Milord, your lordship, I'll show the judgment
Okay.
itself, the subject to your lordship. It is said that it has to be because that is the
That
trend.
is with regard to what? The judgment is with regard to this rule 25 again. Then
General, Milord, general.
general to that is general.
But whether these, how far they are differing, so far as these holidays, hours of work and other conditions are concerned, that we have to take instructions, otherwise I can't offensive. Because it's a huge quantity of people. Therefore, it will have a lot of implications. And we have to ask that. I can't.
And I have got to, that is the problem. We are never finishing of these cases. Again,
Well,
and
Milord, in a way, if you look at the regulation cases, what has happened in 2017 case, KR's judgment, after having analyzed all the cases all over, he finds that the workers involved in that case needs to be regulated. What was the relief granted? They will get the minimum of the basic pay. If your lordships remember, 2017 case. So that is all. We have not,
Jagdish Singh was also-
Jagdish Singh, yeah, lordship is right. 2017, there was a very long judgment. He has surveyed all the cases, regular, on regulation. When will you give contractual work a regular status? He said that yes, these people are doing and they are regular, to be treated as regular. And what was the relief granted? They will get the basic of the scale.
But here, this is a statutory provision.
Look,
This is a-
I'm not saying that. I'm saying this for the reason that that was said in 2017. But our agreement of 2010, if your lordship sees, we have given, his company at least has given the basic of the regular scale to them from 2010 onwards. your lordships will not find even in PSUs the amount of wages which are being paid by this company. They are one of the highest among the PSUs. Therefore, my lord, it is not, it is, if it is a small group of people, one can.
Mr. Pegu, when are you going to start? You're going to give some submission also? You see, the problem is, we're never ending. I think basically you're finished,
Almost.
almost.
Hmm? I have to reply to his 30, section 30 argument.
Okay, then tell me what is section 30 argument? Let us, look, I'm quite fed up. I listen to you all, then again, we don't have time, there's some, and then I forget, again I remember, then.
Let him argue.
No, he's got nothing to argue now. He just wants to counter your section 30, that's all. You've got, what have you got to say? Your only submission now
Yes, sir.
is with regard to, there is a settlement, you have not denied that. The only thing is you have said that there could be a difference between the conditions of the settlement and the actual benefit that can be given under Rule 25(5)(a). And for which matter, I think prima facie, I am of the view
Yes, yes.
that if 25(5)(a) is better, then that should prevail over the settlement.
Right. And that is
Prima facie,
the mandate of section 30
section 30.
of the act.
Okay. So if that is the case,
That is the mandate.
then 25(5)(a) supersedes that.
Supersedes.
Now 25(5)(a) only requires a finding
Yes.
with regard to whether there is any same or similar kind of work.
That if your lordship wants to say, then he has to be directed to take that and apply his mind to that and then record a finding.
So we can send it back to the authority to make a finding as to whether the benefit under this is better or not, and if it is, they should be given.
No.
Provided 25(a).
Provided it can be said that they are doing the same in or similar.
Correct.
That it follows from that.
Correct.
It is,
Correct.
if the finding is that.
The finding has to be there. It has to be
then
preceded by the finding.
consequences are obvious, they have been prescribed.
And that is what you want actually.
Huh.
Because that
That is what he wants.
because that will delay the matter further.
It will be 10 years. It will go again more than 15 years.
But then what to do? I don't have the
The
power or the.
problem is, the order itself is very deficient so far as wage fixation is concerned.
No, wage fixation they
No,
cannot
no.
do.
I'm
Unless-
saying that
unless it comes-
because you have certain parameters by which you decide the parity. If you don't apply those
If
tests,
we go into those aspects, is
no, that is very important because there will be thousands of workers of this.
Actually, I think that is where you are heading.
No,
End of the day.
obviously, because below, kindly see,
Whether
why contract labor is required in a company of having this kind of a exploration. Because once you get a piece of land and you explore, now the country crude oil production is 30% of the requirement. We are depending on import. Your lordship has seen that has become a very live topic now in the newspaper. So if you don't produce here, we are at a difficult situation. But if you want more production, you have to get land where it is possible to even start an exploration. Because it has to be technically possible that there may be some trace of oil or crude.
Yeah.
Unless that, you don't start that because it's an expensive process. And any kind of settlement, you will need a huge number of people on a temporary basis, on a contractual basis. Every oil company does that. One cannot have, and that's a gamble. You may not ultimately get anything. Therefore, it has its own implications for the, because there will be a lot of people who will be in the process, several thousand.
No, I will take just 1 minute time. If I also go to section 12, it will be very much clear that the waste fixation can be done. Fixation of waste can be done.
Of course.
Because this is the condition of license. Rule 25. Now, what should be the condition of license? That is territorially section 12, subsection 2.
Yeah.
What it states, subject to the provisions of this act,
Yeah.
a license under subsection 1,
Yeah.
subsection 1 may contain such conditions, including, in particular, the conditions of hours of work, fixation of wages. This will be a condition. And that condition is to be determined under Rule 25. This is very much clear, below.
May contain.
May contain.
And if it doesn't contain, then what happens?
Certainly, it is up to the authority. He has exercised his power. Deputy level commissioner.
This is for licensing of contract.
Yes,
License.
and this is the condition of licensing. If you also go,
No, so what happens? If
25
supposing what, so having said that, look, so it may contain, may not contain, or even if it contains, can't that be superseded by a settlement?
no, that is the condition of Rule 25. License rules 25. This is what? Nothing else. Form and condition of license. Yes, simple thing, Lord. We are taking too much of time. Form and terms of condition of license.
What to do? You tell Mr. Goswami, why is taking us?
I don't know, my lord.
Well,
We are fed up.
they have
To be very
argued
frank, I am
on-
fed up.
I saw that. I note down in my writ petition how many days the case is going on. And they have taken more days than I have. So don't try to look at me.
Forms and terms and condition of license.
Yes, yes.
So everything is on forms and terms and license. Whatever judgment will be rendered, that will be included in the license.
That is a license for
That is
contractor.
license, contractor's license.
Correct.
So wait. When the new license will be granted, this thing will be incorporated.
No, if your lordship kindly turn to page 70.
Let me finish.
Okay.
Hey,
No, let me finish.
hey,
No, I'm not.
Okay.
Terms and forms and terms of conditions. Miller, a contractor, when a contractor is to supply his contract labor, he has to obtain a certain license. And the ingredients of license is, what are the ingredients
let
of
us see
license?
this form 6.
Yes,
Page 70, that's what I need to say.
form 6, page 70, annexes. form is given. And thereafter the license annexers is
Okay,
there.
so these forms and conditions, the conditions of license that they mentioned that Rule 25, does it cover the principal contractor?
Annexers, no?
Yes,
There
Milord,
is an
contract- this
annexer.
is a contractor's
There is
license.
annexers, contractor's license.
No, it's contractor's license. Does it cover the principal contractor?
Principal employer.
Employer.
No, that is different.
That is different.
If your lordship kindly turn to.
Yeah,
page-
wage, this figure, wage, rates of wage payable to the workman. Clause 4. If you also come, page 70, license, then renewal, then annexer, clause 4. The rates of wages payable to the workman by the contractor shall not be less than the rate prescribed for the scheduled employment minimum wages act and were applicable whether rates have been fixed by agreement, settlement, award or appropriate government less than the separate certificate.
Milord. My lord has.
The
got
principal employer actually
Page
wages,
70, Milord.
then clause 5.
clause
Alexa,
4 of
five.
that.
5A. In case where there is a workman employed by the contractor perform the same or similar kind of work, specifically, same or similar kind of work as the workman directly employed by the principal employer of the establishment, the wage, the rates, holidays, hours of work, and the other condition of service of the
Settlement made between the principal employer and the workman, is it covered by this Rule 25(4)?
Yes. So what, our case is Rule 25(5).
Is it covered? Is the
Your lordship
settlement
is
made-
referring to page 70,
No, I'm referring to Rule 25(4).
25(4).
Yes.
Rule 25(4), the settlement that is mentioned therein, does it pertain to the settlement made by the principal employer?
Yes, Milord.
No?
Rates of wages payable to the workman by the contractor shall not be less than the rates prescribed under the Minimum Wages Act for such employment where applicable, and where the rates have been fixed by agreement, settlement, or award, or by the appropriate government, not less than the rates so fixed.
So does this settlement that is mentioned here,
Yes.
or the agreement that is mentioned here, does it cover the settlement made by the principal employer, or is only relating to a contractor settlement?
No, Milord, Milord, kindly see the nexus they have created under this act. The principal employer will be responsible for the payment of wages that is prescribed.
Correct.
If the employer doesn't, if the contractor doesn't pay them, now the contractor is going to pay on the rates fixed, which the principal employer will tell him, and then he will be paid.
No, might not be.
Yes, yes,
You
that
see,
is also this.
where is that?
I'll give you.
There might be a different rate of employment between the contractor and the principal.
No. So far as wages are concerned, you see, your lordship has seen that these wages have to be paid even in the presence of a
It has to be
representative.
paid, but then does this 25(4) cover settlement made by a principal employer?
Yes,
It-
yes, that is meant for the workers only.
No,
Contractor.
maybe
And
meant
the
for the work, but
concerned contractor will be responsible for implementing that. There is no question about it. The rates of wages payable to the workman by the contractor shall not be less than the rates prescribed under the minimum wage act for such employment where applicable, and where the rates have been fixed by agreement, settlement, or award, or by the appropriate government, not less than the rates so fixed. That is absolutely clear, my lord.
It's not there in black and white. That's what I'm.
No, agreement and settlement. Settlement is part of it. And the last agreement is only the contractor is signing. But that doesn't matter because the liability to pay wages as determined by the agreement with the principal employer, that will be paid to the contractor, who in turn will pay to the employee. And they will be paid in presence of the representative of the contractor. That's the rule. They have taken that trouble even to prescribe that. This 21, that's why I cited 21, you know. A contractor shall be liable for payment of wages to each worker employed by him as contract labor, and such wages shall be paid before expiry of such period as may be prescribed. Every principal employer shall nominate a representative duly authorized by him to be present at the time of disbursement of wages by the contractor, and it shall be the duty of such representative to certify the amounts paid as wages as may be prescribed. It shall be the duty of the contractor to ensure the disbursement of wages in the presence of authorized representative of principal employer. In case the contractor fails to make the payment of wages within the prescribed period or makes short payment, then the principal employer shall be liable to make payment of wages in full or unpaid balance.
25(4) does not make any mention of principal employer's settlement.
No, principal employer shall nominate, and the whole thing is who is the employee? Ultimately, it is the principal employer
You
paying.
said the settlement is covered by section 18 of the Industrial Disputes Act.
Correct, Milord.
That's it.
We have to give a meaning to that.
The definition of settlement is given section 2P. First, section 2P.
The settlement, Milord, means a settlement arrived in course of conciliation proceeding and includes a written agreement between the employer and the workman arrived at otherwise than in course of conciliation proceeding where such agreement has been signed by the parties thereto such manner as may be prescribed and
So it is otherwise than in the course of a conciliation proceeding. So yours is pro conciliation proceeding.
Yes.
So this is otherwise than.
No. Arrived at in the course of conciliation proceeding, settlement.
Arrive at otherwise than in the court.
No, settlement means a settlement arrived at in the
Because-
course of
and
conciliation
includes-
proceeding and includes a written agreement between employer and workman arrived at otherwise in the course of conciliation proceeding where such agreement has been signed by the parties thereto in such manner as may be prescribed and a
Anyway.
copy thereof. Everything.
So you section, okay, then section 30 again, I'll have to fix it.
Yes, now section 30, my learned friend was making a submission on that.
Anyway,
That's it.
I think we'll have to again, we have to fix a date. You're not going to complete. How much time are you going to take?
My argument,
5 minutes.
we have already given written argument also.
So nothing, you're not going to say anything more.
If your lordship wants
No, I
to do
don't
something,
want anything more. I was asking you.
because my senior counsel has argued, then I again argue.
No,
His reply.
because I wanted to refresh my memory.
That's all right. Whatever question your lordship will ask, I will try to.
So you have finished.
I'll just reply to his 30 argument.
Whatever question your lordship will ask, I will give the answer.
Yes,
I will not make any argument.
but how long will you take?
Well, I'll be able to finish it, Milord. When is the time? 4? 4:30. Your Lordship is speaking. I'll be a short submission on 30. Effect of laws and agreements inconsistent with this act. The provisions of this act shall have effect, notwithstanding anything inconsistent therewith, contained in any other law, or in terms of any agreement or contract of service, or in any standing orders applicable to the establishment whether made before or after the commencement of this act. Provided, it is important, provided that where under any such agreement, contract of service or standing orders, the contract labor employed in the establishment are entitled to benefits in respect of any matter which are more favorable to them than those to which they would be entitled under this act, the contract labor shall continue to be entitled to the more favorable benefits in respect of that matter, notwithstanding that they receive benefit in respect of other matters under this act. Nothing contained in this act shall be construed as precluding any such contract labor from entering into an agreement with the principal employer or the contractor, as the case may be, for granting them rights or privileges in respect of any matter which are more favorable to them than those to which they would be entitled under this act. Therefore, my lord, 30 itself, in order you attract 30, there has to be first an inconsistency between a law and the provision of this act. There is no inconsistency pointed out. Because this will have effect if anything is inconsistent therewith contained in any other law, or in the terms of any agreement or contract of service. So, a conciliation agreement under the Industrial Disputes Act is not inconsistent with Section 30 or with any provision of the Contract Labor Act. It contemplates a settlement, is contemplated even under this Act, Contract Labor Act, because it says that if you have a settlement which has given you certain benefit, you are entitled to get it. Your wages are also, if fixed by a settlement, that is recognized under this. Therefore, my lord, unless you can point out, and the proviso itself indicates, my lord, that there can be an agreement arrived at by the employer and the contract labor, whereby they will get benefits.
The proviso,
More, correct, my lord, more.
the proviso provides.
Correct. Therefore, there is an indication that a separate contract for the terms of wages or any other service condition beneficial to them is not ruled out.
So if there is any,
If there is no inconsistency with the act, there is no problem.
no, but even if there is inconsistency with the act, not some other act, with this act,
Act.
the settlement,
Ah,
then they'll have to get it as per this act.
Yeah.
Supposing
Yeah.
they are entitled to some better benefits
No. better-
under 25(5)(a),
Yes, my lord.
then which is better than the settlement made, then they will be entitled to that better benefits, of course, subject to those conditions of having same or similar kind of work
Correct.
as per the proviso to Section 30.
Correct. My lord, if my lord, that condition is satisfied, namely that they are doing the same work and
Same and similar.
similar, then the consequence is also mentioned there. And they will be entitled to everything that a regular employee gets. There is no dispute on that. Only thing is, it has to be, the order has to satisfy that condition precedent. Unfortunately, this impugn order itself is equivocal.
Okay, but.
At one stage, it says that it is not
Still
identical.
we agree to what we are submission. We don't have to go into the issue of, with regard to how the pay or pay scale should be fixed. And
No,
what
no,
are the
that
conditions.
is not.
We don't need not to go into that.
Only thing, even under this act, what are the options? As I was placing before your lordship, first is that minimum wages. That is a prescribed thing. Ours is far more than the minimum wage. Then settlement, that is recognized under the Industrial Disputes Act, which is available in our case. Third, the claim that there is a same and similar, in which case also the 25A prescribes that all the consequences. But there has to be a very important examination by application of the relevant test that they are doing the same thing. If they are not doing the same thing, then that consequence will not come. And so far as section 30 is concerned, there is a judgment which your lordships note of Justice Bopanna, as he then was in the Karnataka High Court, where he went into section 30. The factual element will be different, and I will just give your lordship that paragraph which your lordship will kindly see.
How many judgments are you giving me?
No. Oh, I'll just show.
I am worried, yes, 10 minutes is going to be over.
Yes. No, your lordship has got this.
I don't know whether I have got that or not.
Huh? It is there. And this was also given. So what we have done, my lord, first conciliation settlement is binding, all the case law and all the paragraphs we have relied on, I have given. Then, my lord, contractor not a party. That was an objection we took. There also two decisions are there. Then equal pay for equal work and identical, which I was giving, my lord. That is also mentioned in this clause. My lord, it is the Mukul Kodgole. I'll just make it. Good. One or two, similar to Kaju.
Okay, let me start, otherwise I'll never end.
Okay.
Right. In WPC 8150/2007. Right, Mr. P.K. Goswami, Senate Council, Senior Counsel for the writ petitioner and writ petitioner and Mr. A. Dasgupta, then Senior Counsel for the respondent. Respondent number 3. The impugned judgment and order dated 11/9/2017 passed by the Deputy Chief Labor Commissioner, bracket Central Common Court. Hereinafter referred to as the Commission. Learned Commission is under CALP. The petitioner's case is that in terms of section 12 of the Contract Labor bracket Regulation and Abolition bracket Act, 1970, hereinafter referred to as the 1970. A license No, a contractor. No, a labor contractor has to. Be issued has to be issued a license. And the license has to contain conditions as to the hours of work, fixation of pay. And the license may contain conditions as to the hours of work, fixation of wages, and other essential amenities in respect of the contract labor, as the appropriate government may fit to impose in accordance with the rule, if any, made under section 35. Next para. Section 25 of the contract labor regulation and abolition central rule, 1971. Hereinafter referred to as the 1971 rule. Requires that every license granted under Rule 25(1) or renewed under Rule 29 of the 1971 rule shall be subject to various conditions, and that the rates of wages payable to the workman by the contractor shall not be less than the rates prescribed under the Minimum Wages Act, 1948. And where the rates have been fixed by agreement, settlement or award, or by the appropriate government, not less than the rate so fixed. Rule 25(5) small, Roman 5, bracket A small, provides that in cases where the workman employed by the contractor performs the same or similar kind of work as the workman directly employed by the principal contractor of the establishment, the wage rates, holidays, hours of work, and other conditions of service of the workman, of the contractor, shall be the same as applicable to the workman directly employed by the principal employer of the establishment on the same or similar kind of work. The proviso to Rule 25(5) provides that in case of any disagreement with regard to the type of work, the same shall be decided by the learned commissioner. Next para. Rule 25(5) small, bracket B small, states that in other cases, the wage rates, holidays, hours of work, and conditions of service of the workman of the contractor shall be such as may be specified in that behalf by the learned commissioner. Someone's feeling cold? Huh? I'm going to start feeling hot then. No, it's okay.
avoidable married. Avoidable married. No, no,
No, no, it's okay, it's okay. I can bear it another
no, no,
few minutes only. In Shillong,
Because of age difference. We are very much older.
not only that, not only that, it depends upon where you are, where you've been living for some time. I was there in Shillong yesterday and day before. Some wearing jackets, some not wearing jackets. Depends upon the person. Next. The case of the petitioners is that the rates of wages payable to the workmen by the contractor cannot be less than the rates prescribed under the Minimum Wages Act 1948. Secondly, the rates of wages payable to the workmen may be fixed by agreement, settlement, may be fixed by settlement between the principal employer, that is the writ petition, with the workman in terms of Section 18 of the Industrial Disputes Act 1947. Thirdly, in cases where the workmen employed by the contractor perform the same or similar kind of work as the workmen directly employed by the principal contractor of the establishment, the wage rates, holidays, and hours of work and other conditions of service shall be the same as applicable to the workman directly employed by the principal employer. In other cases, provided that in case of any disagreement with regard to the type of work, the same is to be decided by the commission. It is only when the first three conditions are not fulfilled that Rule 25 bracket 5 small Roman 5 small and bracket B of the 1971 rules come into play, wherein the learned commissioner may specify the wage rates, holidays, hours of work, and conditions of service of the workmen of the contract. Next paragraph. The counsel for the petitioner submit that in the present case, there being various settlements made between the principal employer and the workman, the latest being
Between contractors also there,
the latest being on
22, 9/11/22,
29/11/22,
at page 136.
bracket page 136, wherein the contractor was also a party
Principal employer as a witness.
and the principal employer was a witness. There was no occasion for the learned commissioner to have applied the provisions of section, rule 25, bracket 5, bracket A and bracket B of the 1970. Next. The learned counsel for the petitioner has also taken this court through the impugned judgment and order, and especially at page 75. Especially at para, there's no para. Oh, there's no para. And especially at page 75 of the writ petition, wherein an observation has been made by the learned commissioner to the effect that there was no total similarity in the job content of the work of the contract workers and the permanent employee of Oil India Limited. However, it had also been established that there was similarity in the job content of these workmen to a great extent, with a few exceptions. And neither here nor there. The exact words used in the impugned judgment is as follows. You take this out in between blue, blue and blue, page 75. Next. On the other hand, the learned commissioner in page 80 of the writ petition of the impugned judgment and page no, and in the impugned judgment and order at page 80 of the writ petition has stated that contract workers categorized as WCL listed 1, Roman 1 big, comma, listed, then comma, then 2, Roman, and 3. Engaged by MS Oil India Limited, Duliaja, have been found to be performing the same and similar kind of work as of regular employees of the company. And hence their monthly wages should commensurate with their volume of work, comma, hours of work, comma, weekly off and other conditions of service, with a view to bring about parity in comparison to regular employees. The learned commissioner thereafter fixed the wages to be given to WCL 1, 2, and 3 for security guards, comma, medical attendant, and cleaner / help. The learned counsel for the petitioner sub that when Rule 25 bracket 5 bracket A of the 1971 rule only requires the learned commissioner to take a decision as to whether the contractors, laborers have performed same or similar kind of work, whereupon the benefits that are given to their permanent employees would automatically be provided to the contract laborers as per the prescription of the said rule, comma. The learned commissioner could not have gone beyond Rule 25 5A and fixed the wages to be payable to the contract laborers beyond what was being paid to the regular incumbent. That's okay. Have I missed out something?
Only thing is, that discussion, whether it is same or not, he has failed,
first
he
of-
has been speaking
He
in
further,
two
he
voices.
further submits that
He has been
besides
speaking
the
in
above,
two voices.
there is no discussion made by the learned commissioner with regard to how the work done by the security guard, comma, medical attendant and cleaner slash helper could be said to be same or similar kind of work as done by the workman directly employed by the principal employee. In the absence of any reason for coming to such finding, there was no ground for coming to a decision that they performed same or similar kind of work. The learned commissioner in any event could not have fixed wages for the contractual laborers, which was not in consonance with the wages being received by the regular workmen. That's all. I think for the time. Huh? When do you want? You have got anything else to show? There is some with Mr. BD Das. What is the difference?
No, that will be, we have to address your lordship on that.
Separate case altogether.
To some extent, overlapping, but.
So basically, okay, so section 30, so next, this right there. Mr. A. Das Gupta, learned counsel for the respondent, on the other hand, submits that, what? Submits that,
Section 30 of the Act.
section 30 of the 1970 Act.
1970 Act.
What?
Specifically provides that provisions of this act shall apply even if it is inconsistent with any other act or agreement. Now, the action of the Labor Commissioner, Deputy Labor Commissioner, is in pursuant to the section Rule 25(5)(a), and his action will prevail over any other act if it is inconsistent.
That means that the action of the impugned judgment and order has been made in consonance with Rule 25(5)(a) of the 1971 rule. And in view of section 30 of the 1970 Act, the inconsistency with inconsistency of what?
Of the industrial inconsistency of, let us be very, very clear, inconsistency with the provisions of section 18 of the Industrial Dispute Act
With
with the action taken by the Deputy Labor Commissioner. His
the
action will-
inconsistency
even if there
with
is
the
an
settlement made under section 18 of the 1947 Act, vis-a-vis vis-a-vis Rule 25(5)(a), required a decision to be made under Rule 25(5)(a).
but shall prevail.
So as such, there was no infirmity in the decision or in the impugned judgment and order passed by the learned commissioner under Rule 25(5)(a).
Right. That apart for equal pay for equal wages,
25(5)(a) of the 1971 rule.
that apart for equal pay for equal wages, judgments rendered is not applicable here because there is a specific provision under Rule 25A. I have referred some judgment also on the last occasion.
I know. I'll have to look around. We'll fix a date. Just pause.
I have referred some
Not date.
judgment. Judgments are with them.
Friday. Then. Friday. We'll fix on Friday.
This Friday I have some problem. I have to go to HR. Thursday,
Actually, I'm not there. I have to go to Delhi also. Okay, after then, November 11. Mr. Goswami. Okay. 13. Just pass that, huh? We'll take it after three. Pass the short order on. Maybe, I'll see. Basically, we'll make it short,
best. Yes, is within narrow compass.
but very confusing the way you all are arguing.